Maybe I started to make a mention in it. It's a rate appeal of 2022. Appeal has been preferred by the state against the judgment of a single judge, wherein the disciplinary proceeding has been paused in action. In the meantime, an application has been filed by the respondent to stay of that disciplinary proceeding in Lordship. That disciplinary proceeding is continuing and the notice has been issued to the witnesses for examination.
This is heat appeal, my lord, 2018. My lord directed for listing over 20th March. In the meantime,
Page starting, sir. Another, I have filed, I have for modification of order.
My lord, it is an admission matter. It was listed before your lordships, but it has been delisted. OGLS matter.
Supplemental item number 1.
Item 1, may I please? Last occasion, last item, my lordship was directed to take instruction from the present petitioner issue. I only pay some more time taking instruction from the present petitioner.
Learn counsel for the petition.
one thing I may submit. The heat is not maintainable.
No, that was, I will satisfy on the said day, my
No,
lord.
no.
The dispute is-
provides against any order of the appellate tribunal of 58 is the appeal before the Honorable High Court, not read.
My let's see, the read, the dispute is 2 and 10, my lordship. The react is come into 417. The read is maintainable on the said ground, my lordship.
We are just adjourning it. The
Aye.
learn counsel for
Aye.
the petitioner sits for an adjournment, put up this matter after the modification.
Obliged.
Item 2.
May I please, my lord? By filing this writ petition, the petition has challenged the order dated 24 September 2024. As on the London City Court of Bench Court in way number 732 over 2012, my lord. That is Annexure 10, page 61. So going to that, my lord, may I pray your lordship kindly give a glance. Annexure 7, my lord, page 44. Earlier, the London Tribunal was pleased to dismiss my case.
You
Applying-
came again remanded,
My lord.
but the order is, what is the illegality in the order?
My lord, in this case, my lord, what happened during pendency of the original application, my service was terminated, my lord. By order dated 9/9/2020, my lord. I have filed an application for amendment that was allowed, and that this order became the order impugned in the original application, my lord. After amendment, no additional counter filed by the opposite parties. In absence of any averment or ground to the stand taken in the original application, the London Tribunal has given so many observations so much to my lord and dismissed my case, my lord. My lord, my grievance before my lord that in the year 2003, I appointed as archery coach, my lord. I continued till 13 without any protection of court. By virtue of interim order passed by London Tribunal, I continued till 2020, my lord. During pandemic COVID-19, they have passed the order of termination and it disengaged me service retrospectively, my lord. So I raised termination, they have the power, they can terminate me, but termination cannot be retrospectively. But in absence of any stand supporting to their decision, they have not filed any counter. So, but the observation given in the impugned order is so moto by the tribunal, my lord. Lots of imagine, my lord. I represented not only the state but also the country, not only national levels but international levels, my lord. Now I am a beggar, my lord, after rendering more than 17 years of service, my lord. Now I am aged about 53 and I have no for my survival, my lord. That's why the petition is before, my lord. Now by virtue of the judgment rendered by the Honorable Appeals Court in case of Jago versus in India, now I am eligible to get benefit of that judgment for regularization, my
Why
lord.
you say that counter affidavit has not been filed?
My lord.
See paragraph number 4.
My lord, initially they are filed in the 14.
Yes,
Amend,
that was remanded back to the, it's not that,
my lord,
why they will again
For-
file the counter affidavit?
my lord, I have made an amendment in the year 2020, my
It's
lord.
all right.
After 2020, there was counter, my lord,
Yes,
to my amendment.
whatever they are, that has been considered.
So far the new pleadings made in the original application
Yes.
by virtue of amendment, not replied by the opposite parties by filing any counter, my lord.
Hmm.
The original counter filed in the year 2014, my lord.
Yes.
But I have made an amendment, challenge the order impugned in the year.
That amendment petition has been allowed.
Yes, my lord.
Where is it order?
Well, I have not ordered. Your lordship kindly give a grant.
What is your amendment petition, when it was ordered? And
Your lordship-
whether you have filed the consolidated original application
My lord.
or not, and have you served a copy on that?
Yes, my lord. Your
Very,
lordship
very
kindly
good documents.
give a glance. Your lordship kindly give a glance. Para 10, I have made a specific averment to that.
No,
Ah.
whatever government you are not, we want the documents. IA, the IA's order, the consolidated original application, service of its copy on the Council for Union of India.
May I pray, my lord? Your glance page 62. The prayer
Have you
portion.
filed those documents? Will not look at your, if the document, government taken in the writ petition is not supported
No,
by.
the Lord Tribunal has quoted the prayer. In that prayer portion, it is available, my lord.
No,
But
you are canvassing a point that the counter which has been filed, it was at the first instance,
My lord.
and after the matter was remanded to the Central Administrative Tribunal for consideration afresh, you filed an interim application for amendment that was allowed. Against that, there is no counter affidavit. So for that, you are to satisfy us what is that interim application, when it was allowed, what was the nature of prayer in that interim application, where is your consolidated original application, whether it was served on the Central Government Council or not. If that is not there, then why they will file the counter affidavit?
Then your lordship may grant some time. I will collect that amendment order, my lord, by which my MA was allowed.
The petition.
Lordship, please, I am appearing on behalf of the opposite parties, your lordship. Earlier, when your lordships had remanded back the matter, the lordships had not taken into consideration the merits of the matter, only because it was pronounced 2 months later than the date of reservation. On that ground itself, it was remanded back to the administrative tribunal, your lordships. It was not, the order was not on merits. So a new counter was not required at all.
The writ petition has been filed by the petitioner, Ashok Ghosh. The order dated 24/9/2024, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 732 of 2012, in dismissing the original application. Stock. It seems no, it is the submission made by the Land Council for the petitioner that the original application was adjudicated on merit at the first instance by the London Central Administrative Tribunal, and final order was passed on 22/4/2022, dismissing the original application. And the said order was challenged before this court in WPC number 16429 of 2022. And this court had order dated 22/2/2023 set aside the order of the London Tribunal and remitted the matter back for fresh disposal. And thereafter, the petitioner filed an application for amendment of the original application, which was allowed, and the consolidated original application was also filed before the Land and Central Administrative Tribunal, and copy has been served on the Land and Council for the opposite parties, but no counter affidavit has been, no additional counter affidavit has been filed by the opposite parties, though they had earlier filed the counter affidavit prior to the amendment. And therefore, the amended portion of the averments taken in the original application has remained uncontroverted. But the Lenin Tribunal on its own stated so many things in the impugned order without taking note of the amended portion of the averments taken, and dismiss the original application. Since the application filed for amendment, the order allowing the amendment, the amended original application have not been filed along with the writ petition, let the Land Council for the petitioner file all those documents by next date, put up this matter on after summer vacation. Yes. Mr. Ashutosh Manti, Land Council. You are the Land Central Government Council
Yes, Your Lordship.
and Central Government Council for the Union of India is present. Yes, next.
Item 3.
Established.
Thank you, Judge. In this case, I have filed one IA party manager. And general manager Mohanadi Coalfield Limited.
You have filed or you will file?
Already filed madam. 6529 IA.
General Manager Mahanadi Coalfield Limited
Good idea.
is to be added as opposite party number 7. And in this case, who are the opposite party? State. And then Mahanadi Coalfield, so on so. Notice has not been issued.
No wonder.
So, yes, it's a formal IA number 6529 of 2025. There's an application for amendment seeking to add the General Manager Mahanadi Coalfield Limited, Hingula area at post transfer likhai schedule as opposite party number 7, na?
Yes, sir.
7. Land Council for the state who has received the interim application has no objection to such prayer. Accordingly, prayer made in the interim application is allowed. The Land Council for the petitioner shall file a phrase cause title. You just file.
So,
Is it ready?
yes, sir. So I have a consolidated cost title and filed madam.
Fine.
There is-
अच्छा ठीक है नो 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 गुड केवल 2 पेजटा फाइल करछन्ती
Yeah, say
2 पेज रे कोन आरंभ होईची चेयरमैन कम मैनेजिंग डायरेक्टर देखियो चेयरमैन कम मैनेजिंग डायरेक्टर ओके last two sorry have been favored
yes.
अच्छा देखियो have been favored already and that copy has already been
Yes,
served. The Land Council for the petitioner has already filed the amended cause title, which is page number 2 of the writ petition. The same is accepted. The yes, you can argue the matter on me. What is your prayer?
In July area, I mean, on a place for the employment. Yesterday, one matter was disposed of in this like manner. That matter has been disposed in WPC number C. This is the order.
No, here notices are to be issued. This Mahanadi Coalfield is a party, and
Similar matter has been disposed of in filing a representation to the.
representation is already there. You have already filed a representation, annexure 6. That is before the Jillapala Onugod, one opposite party number.
Earlier occasion, the representation file, representation was filed.
uh,
It was remanded to collector to consider the claim of the petitioner. Collector has awarded, passed the order directing to the engagement. That order was under challenge before the Honorable by the MCL. That was dismissed. Against that dismissal, the previous writ petition were again considered on that basis.
Now this
This
notice go एगुड़ा इतने गार action ये चीज़ इतनी challenge करती है.
2017, the petition was.
Look, this writ petition has been filed by the petitioner Somesh Behera with a prayer for a direction to the opposite parties to provide employment as per R&R policy in lieu of the land acquired by LA case number 26 of 1985. It appears that earlier, never came like that, never before this honorable court.
Already disposed of my.
Dispose of our say connection re apono aguru aschandi writ petition dispose of pala tapare direction ala CSC order ku challenge kale kemti kardele lekhidele never before this honorable court matter out of which man it covers everything. A connection re apon jaha lekhichandi konosi writ petition aguru file enatla, it's an incorrect statement.
So many repetition has been filed in.
The upon we are asking about the petitioner. Are you making a submission that the petitioner has not earlier filed any writ petition?
The petition has not filed, madam.
So why from we got?
No, that order policy. What a writ petition file letter remanded the collector batch of writ petition.
No.
Collector.
Hey, this petitioner
Petitioner has come.
Petitioner or not?
Then
They claim is the order.
maybe that similar case is a pare, pon a pare, seta. So lekhon. So the he order ta jo dejen annexure 5 ta kon.
I think the repetition challenged by city manager, general manager. That was in our favor, madam. In this repetition, honorable court has directed to comply the order of collector manager.
No, that writ petition was dismissed,
Yes.
which was filed by the MCL.
Yes, yes.
See, who order to challenge karte kon?
Collector order that is unacceptable.
Thereafter, he also filed one
To
review
pass the
petition.
nahi thik challenge करते 30/11/2016 order.
Yes, yes.
At annexure page 45 में annexure 3.
अच्छा. All right. Let me do. The London Council petitioner submits that similarly situated persons approach this court in WPC number WPC number 4577 of 2015 and other writ petitions which were heard analogously and High Court order ta kain High Court jo order ta o eta challenge heitla koda 30/11/2016 and by which general manager challenge करते order of the
Collector.
collector. The collector order is similarly situated favor order हेतला ये ना.
Similarly situated claim थला analogous hearing.
अच्छा. लिख ठीक है जी. Approach this court knowledge लिख देवे. Approach the collector है ना Hon'Ble and height if those are heard analogously order टा केबे पास ही जी. जोटा देई जने annexure 3 রে
এইটা, ওই 16
30/11
30 নভেম্বর
30/11/2016 the collector directed the MCL authorities to disburse the unpaid compensation amount to the left out awardees or his oblique her legal heirs in case of death and to extend employment benefit to one member of the awardee oblique petitioner's family. He further submits that the said order dated 30/11/2016 passed by the collector on board was challenged by the general manager Mahanadi Coalfields before this court in WPC number 19875 of 2017 and the writ petition and order date judgment and order dated 22/12/2022. The writ petition was dismissed. এই order against ଆଉ କିଛି challenge करनाहांती
রিভিউ ହେଇଥିଲା that
ଏଇଠି?
has been also dismissed.
କାଇଁ ସେ review order କାଇଁ
SLP also filed and that
ଉନାଦି ରଖିଲେ କଣ ପାଇଁ ଆପଣ ନିଜ ପାଖରେ ଯୋଉଟା ଆପଣ ଆଉ ରଖିଦେଲେ କଣ ପାଇଁ ଦିଅନ୍ତୁ।
letter I got this copy.
It is further argued that the general manager Mahanadi Coalfields filed the Supreme Court order এটা not be inclined of এটা কোଉଥିରେ pass ହେଇଛି order dated 22/12/2022 আচ্ছা রিভিউ পিটিশনটা ফাইল লিখুন কোন লিখলে filed review petition number RVWPET number 217 of 2023 before this court for review of the judgment and order dated 22/12/2022 passed in WPC number 19875 of 2017, but the same was had order dated 21/6/2024 and then the MCL authorities approached the Honorable Supreme Court by filing SLP number 13/14 of 2025, but the same was also dismissed. The Land Council on 2/1/2025, the Land Council for the petitioner produced the copy of the order dated 2/1/2025, which is taken on record. The Land Council for the petitioner submits that a representation has been filed before the now who is to this the relief which you are seeking for is to be granted by the MCL authorities and you have added them as party. We have so unless notice goes you cannot
Yes, sir.
because the direction will now be to the this collector and collector will pass similar order, so that will create problem. Hello, he further submits that a representation has been filed before the collector on board highlighting the grievances on 6/2/2025, but the same has also not been acted upon. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission, and counsel for the state accepts notice on behalf of opposite parties number 1 and 2.
My lord, I prefer 2, 3 and 7.
1 and 2 सी
One
रिसीव
and-
करियो ना
Yeah.
आउ के कोना सही तो
3, my lord, 3 is also.
Hey,
and 7.
मान जी कोर्ट नोटिस जीवो ना
3 to 7 notice.
3 to 7 notice you. Lagon. So far as the opposite parties number 3 to 7 are concerned, requisites for issuance of notice by speed post with proof of delivery be filed within a week. Matter to be listed after 4 weeks. Counter affidavit if any be filed in the meantime. Yes.
Now, similar matter is 9, 10, 11.
Yeah, just a minute.
16.
तारो नंबर फंबर अलगा सब थिवो
No, my lord, similar.
नहीं माने ए जो सब थे ई गोटा रिलाय करछन तो 7-1 अच्छा ता देरे इंटरिम एप्लीकेशन फाइल करछन दी अमेंडमेंट पे
Filed in 9, my lord, 10.
just a minute is so notice ये एटा होची दिस इज सिमिलर टू कोको आइटम
9, 10, 11,
9 10 11
12, 13, 15 and 16.
9 10 11 12 13 आउट गुडा
15 and 16.
15 इंटरिम एप्लीकेशन 9
No, my lord, I have, latter I have filed impleaded in party. Latter.
Party ଅଛନ୍ତି MCL ବୋଲି।
Already filed.
ଅଛନ୍ତି?
Yes, my lord.
ताले ये जो आउट 16 तो
आଜ୍ଞା।
16 आधे से सेमती जेमती इंटरिम एप्लीकेशन फाइल करछन जो अलाउ है अमेंडमेंट आर्डर करिकिन से ऑर्डर पास करिवे यदि चेंज करिया था करिवे बाकी केवल 15 टारे से ऑलरेडी फाइल कर दिजन तो अमेंडमेंट दरकार नहीं था है ना बाकी एई ऑर्डर टा किंतु ताजे रहइबो और ताजे लिखियो लीज दिस मैटर अलोंग विथ हिज लिटिगेशन सब बड़ा को इशू नोटिस
15, 16 ଦିଟା already.
15 16 ठीक है 15 16 रे इन अमेंडमेंट अछि सेत पय ठीक अछि 15 टा टिके अलगा ऑर्डर टा हो अमेंडमेंट टा नाही यस नेक्स्ट
Item 4.
Respect the order of the claim commission to provide the arrender benefit, the same has not been provided to the petitioner. This is the area covered under the judgment of Matthias CORAM, 2010-11 SCC 269, 14 villages. Your lordship, I will take your lordship to Annexure 3 at page 41.
no the who was before the
Petitioners lost their homestead land and agricultural land.
so
And
the
they have
order
paid-
which you are pointing out but if that is annexure 5
My lord.
एटा एते कोन आपण पार्टी थिले आपण को इंस्टेंस रेट आइतला
Yes, at the instance of the petition number 1, and there is specific order,
काई जणा पुनी किछ
the constantly given any concern.
हाउ कैन यू नो
Their name has been mentioned,
पोखरी
page
And it is
42,
2 rates.
hard
this
petition.
case number 15 of what 15 of what miss case number 15 of
15 of 2016, they mention only the case number, not by number. And there they mentioned the hard petitioner Kanaklota Lenka, the Land Council, Mr. P.K. Mahapatra and R.K. Naik for the
Wait,
state manager MCA.
Is petition number 1.
Petition number 1. And there, the name of next page, page 43, towards the bottom, when Land Council, Mr. Mahapatra and R.K. Naik are asked whether they have moved the Honorable Supreme Court challenging the order of commissions.
yes yes, yes.
1 minute.
paragraph 6.
Here the petitioner is Kanaklata Lenka.
Yes.
Who is the petitioner in this?
Petitioner 1 is Kanaklata Lenka.
Okay. And who are the other two
petitioner 2
petitioners?
and 3 are his son or sons.
Okay.
Your Lordship, I will take your
What
Lordship.
order was passed by the claim commission?
Your Lordship, paragraph 6 of the at page 42.
First, come to paragraph number 2.
Well, this case has been filed by one Kanaklata Lenka, wife of Gayadhar Lenka. Her prayer in case is to take immediate steps for providing monetary compensation and resettlement and employment to her family members and to compensate her for delay in providing the RRN benefit, causing harassment both mentally, physically, and for financial loss, traveling expenses to come to the commission time and again to get.
Now you come to the operative part.
Paragraph 6,
Paragraph
page 43.
Yes.
When the Learned Counsel Mr. P.K. Mahapatra and Mr. R.K. Naik are asked whether they have moved the Honorable Supreme Court challenging the order of the Commission in civil case number 170 dated 2012-2013, they repeat that they have not preferred any appeal before the Honorable Supreme Court against the order of the Commission. However, it is submitted that they have filed one civil case in the office of the Commission on 13/3/2015. A copy of such petition is filed. This is most unfortunate that MCL, though a public sector company, is adopting dilatory practice in the present case in providing monetary compensation and resettlement to the petitioners and employment and resettlement to for two sons. The implementation of the order of the Commission is stayed on the ground of filing of a belated petition before the Commission challenging the correctness of the order, more particularly when such a petition is not maintainable. Time and again, MCL was requested by the petitioner to implement the order, but it is not implemented for last 2 years. It shows that how MCL is overreaching the order of the Commission. If MCL was not satisfied with the order of the Commission, it was open to MCL to challenge it before the Honorable Supreme Court. But without doing so, it is arbitrarily the order of the Commission. In the above circumstances, once again, MCL is requested to implement the order of the Commission within 1 month. Period of 1 month will run from today, as the order is dictated in presence of the Learned Counsel appearing for the MCL, State Manager, MCL, and the petition. MCL is directed to submit the compliance report.
So what happened thereafter?
Thereafter, they have not implemented on the ground that they have filed an application for review. There is no such provision for review, but that application was heard for on several occasions. But in the meantime, the Honorable Supreme Court closed down the and directed for remittance of our record to the MCL. We have filed such, your Lordship may imagine, we have filed certain important documents against the MCL. Now MCL may withhold those documents. Even your Lordship will call for those documents, they may detach from the file. But without consent, however, since the order has been passed by the Honorable Supreme Court, we cannot say anything. But now they have taken all the records and it is in the office of the MCL. And this is a genuine case. The Honorable Claim Commission has time and
What
again
is the order of the Honorable Supreme Court?
for closing down the commission.
Oh, no, that is there.
But
Then, no. After this, this claim commission passed the order on 22/11/2016. Why have you approaching this court now in 2025? What you were doing earlier?
I have mentioned in paragraph 1,
What?
their review petition was taken on several occasions for hearing. Page 4, the MCL authority have filed civil case number 1093 of 2015, page 4 of the brief, paragraph 1.
Civil case number?
1093 of 2015.
So that was prior to that. Because this order was passed on 22/11/2016.
So that case was continuing. Before the claim commission to review order passed by the claim commission, the petition number 1 had filed miscase number so and so. in civil case number 170 of 13 for implementation of the order passed by the claimant. Both the cases were heard on several occasions and order has not been passed. In the meantime, the order of the Honorable Supreme Court, the claim commission has been closed. On if your lordship will call for the records, it will shown in several occasions this matter has been heard before the claim commission. And since the matter was pending before the Honorable Supreme Court,
No. I think that we are not clear to you. The order of the claim commission,
right,
under Annexure 5
my lord,
was passed in Miss Case number 15 of 2016 and the order is dated 22/11/2016.
16.
Right?
My lord.
Some directions were issued to the MCL and according to you that MCL didn't carry out that order, right? So, when we put a question to you that if that is so, then what you are doing from 2016 till today? You said that a review petition is pending, but which review petition is pending before
Civil miscase, civil case number 1093 of 2015.
It was prior to that. It was when the order is passed in 22/11/2016. How can a review petition be filed in 2015?
Your lordship may kindly have a glance to
Can you
order-
show us the application?
page,
Review
page,
application
page
filed.
31. They have not served a copy to even to us. My lord, your lordship,
2016 रे गोटे ऑर्डर पास हेले रिव्यू पिटिशन जे तापर फाइल हबो सेटा 2016 किबा 17 रे हबो आपण 2015 रे केमति कहउछन रिव्यू पिटिशन फाइल हला
टिके सुनिए
तो सामते पचार के
पेज 41 तक ये देखिए
31.
that was passed by Justice Paritha. Order dated, that is miscase number 170. You will see my mark in the left hand side margin.
So that was against some other order passed.
Oh, same order.
Sorry?
My lord, the initial order, Kanakalata had filed civil case number 170, and in that 170, Justice Paritha, Honorable Justice Paritha, directed to provide the R&R benefit. Since they did not provide, then I filed a miscase, that is 15. This order passed in on 2012-2013 in civil case number 170, a review has been sought. Therefore, the review is of 2015. And that fact they have mentioned.
This miscase order they have not challenged. The MCL has not challenged.
No. Neither the main order passed in 170 nor the miscase order has yet been challenged.
All right. This writ petition has been filed by the petitioner, Kanakalata Lenka, and two others, challenging with a prayer for a direction to the opposite parties for providing rehabilitation and resettlement benefits to the petitioner as per Odisha R&R policy 2006 and as per the order passed by the Honorable Claim Commission within a stipulated time. The Land Counsel for the petitioner submits that the petitioner, Kanakalata Lenka, filed civil case number 170 of 2013, claiming for R&R benefit under category 1. And before the Honorable Claim Commission, Land Claim Commission, and the prayer was allowed as per order dated 2012-2013, holding that the petitioner is entitled to get such benefit. And thereafter, though monetary compensation and resettlement have been awarded to the petitioner, you have stated also in that order employment and resettlement have also been provided to her two sons, then what remains to be done?
Not provided,
Not provided.
not provided.
এটি দেখুন না প্যারাগ্রাফ 3 রে লেখা হয়েছে অর্ডারটা ইমপ্লুড অর্ডারটা এই যে 22/11/2016 প্যারাগ্রাফ নম্বর 3 একটু পড়ে আসুন।
It is submitted on behalf of the petitioner. The commission passed the order on 2012-2013 in civil case number holding that the petitioner is entitled to RR benefit under category 1. Pursuant to the said order, in the PF list, monetary compensation and resettlement have been awarded in the to the petitioner. Employment and resettlement have been provided to her sons, namely Ramakanta Lenka and Divyakanta Lenka.
What could
that is in the PF list. But it has not been provided to the petitioner.
The PF list kali mention hai.
Mention it.
All right. And in that said PF list, it is also mentioned that employment and resettlement have been provided to the two sons of the petitioner, namely Ramakanta Lenka and Divyakanta Lenka, who are the petitioners number 2 and 3 in this writ petition. The Land Council for the petitioner submits that since the MCL authorities did not take any step for implementing the aforesaid order dated 2012-2013 passed by the Land Commission, the one miss case number 15 of 2016 was filed by the petitioner with a prayer for taking immediate step for providing monetary compensation and resettlement and employment to the family members and to compensate for miss case number so and so was filed by petitioner number 1 kar debe hai na na likhe debe Kannakulata Link. To compensate her for delay in providing R&R benefit causing harassment both mentally, physically, and for financial loss, traveling allowance to come to the commission time and again to get or legitimate benefits. The said miss case was disposed of by the order dated 22/11/2016, and the MCL was asked to implement the order of the Land Commission within a month. The Land Council for the petitioner submits that neither against the original order dated 2012-2013 passed in civil case number 170 of 2013 nor against the order dated 22/11/2016 passed in miss case number 15 of 2016, the MCL authorities approached the higher forum. However, a review petition was filed before the claim commission. Tar number ta hochi which is registered as civil kete number code dekhuthile apna
2093 of 2020 2015
কোড যেটা লেখা হয়েছে কোডটা দেখুন
page 4 রে লেখছি the MCL authority have filed civil
page 4 মানে আপন writ petition civil case number 1093 of 2015 before the claim commission to review the order passed by the claim commission on dated 2012-2013 in civil case number 170 of 2000. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accept notice on behalf of the opposite party number 4. Extra copy of the writ petition be served on the Land Council for the state. So far as opposite parties number 1, 2, and 3 are concerned, requisites for issuance of notice by speed post proof of delivery filed by within a week, matter to be tested after 4 weeks. Counter affidavit will be filed in the meantime. Yes.
Item 5.
Proceed.
Yes, sir. Here, petition of the lordship, the land house tree under the Khordha Bolangir railway link project. The meager amount of compensation was paid. Same was received under protest and sought for reference under section 64 of the Act. And reference of the lordship is allowed on
Reference order kahin?
Annex 1. Reference is allowed on 31/8/2023. But till date, they have not paid the enhanced compensation.
Executing court na kona ame?
My lord.
I'm going to executing court. Tanga order ta pass hala. Equally, upon setting file kariyo. Ethi kon padega?
No.
There is no provision
Section
for
64 of the Act.
filing execution proceeding.
No, as per section 2013 of the Act,
No, no.
what land was acquired.
Presiding officer, LAR authority, ଯଦି ଗୋଟେ order pass କଲେ ସେଇଟାକୁ ସେ ଯଦି
not the aggrieved party.
ହଁ
He is not the aggrieved party.
And not the
73 award was passed. It is not being paid. 73 mechanical plans.
7 ହଁ
73
no no ଅମିତ କୁମାର ନିଆଳି କିଏ?
He is one of the land house along with OP numbers 2
ଅମିତ
and
କୁମାର
3.
ନିଆଳି ପରା ପିଟିସନର
ଆଜ୍ଞା
ଏଇଟା କପି ଅଫ ଦି ଜଜମେଣ୍ଟ ରେ ତା ନାଁ ଅଛି ଅମିତ କୁମାର ନିଆଳି
ତାଙ୍କ ଫେଭର ହେଇଛି ଏଟା
ଆଉ କଣ ନା ସିଏ କଣ ଆଗ୍ରିଡ୍ କଣ ମୁଁ କହିବା କଥା ଏଇ ଯୋଉ ଅର୍ଡରଟା ତା ଫେଭର ରେ ପାସ୍ ହେଲା କ୍ୱେଶ୍ଚିନ୍ ଇଜ ପୁଟ୍ that if the order has been passed in your favor, can you not initiate execution proceeding?
So far the 2013 Act is concerned, there is no provision for execution.
2013, the provision of the
2013 Act.
73 ର ଗୋଟେ application ଦେବେ to collector.
ଦେଖିବ order ଟା pass ହେଲା section 64 ଅନୁଯାୟୀ
64 ରେ 64 reference. Order
reference
passed 69 ରେ
60 just a minute. Determination of the award by the authority. Yes, in determining the amount of the compensation to be awarded for land acquired in so and so, the authority shall take in addition to market value. The in addition to okay, then form of award asigala 70.
Okay.
So signed by the and shall specify the amount. So that has been done in Annex 1.
Yes.
Okay.
Every such award shall be deemed to a decree.
Yes.
And the statement of grounds so and so. So
CPC ke jibo.
So CPC report to the
order 21
reference have been dismissed. Reference is made under section 64 of the Act. And that adjudicate reference is made in case any person not satisfied with the award by taking recourse to section 64 of the 2013 Act. Reference to the land use code. Reference was allowed. By taking it to section 69.
And it has been held that you are entitled to more amount.
More amount.
So that has not been paid.
Yes.
So
You see here the OP number 1, he himself has appeared, he contested the proceeding, independence order was passed.
It is a decree now.
Now it's a decree. So it needs to be executed. So in accordance with the civil procedure code.
Order 21 he has to approach to the.
I've got a limited grievance.
No.
On 21/8/2023. Order was passed. Almost 1.5 years passed. The ILO himself as sitting silent to government and let direction, let the opinion want to take a decision basing on the award passed by the referral.
One is a lax jurisdiction.
If the reference would have been disallowed against that under section 74 of the Act, I could have filed a
କିଛି ଆପଣ ଫେଭରରେ ଅର୍ଡର ହେଇଛି ସବୁ ହେଇଛି ତା ସତ୍ତ୍ୱେ ଯଦି ଦେବେନି ଆପଣ ଏବଂ ସ୍ପେଶାଲ provision, the provision is very clear that it would be a decree.
Yes.
Under the section 2 so and so of the civil procedure. So you can file execution, you can initiate execution proceeding in accordance with law. Why will
am I limited given that?
No. Look, this writ petition has
May I
been
pay one thing, Lord?
Yeah.
You must pay dispose of the writ petition, given liberty to the petition, keeping in the award passed by the referral court and repent to the authority. Authority to take a decision with the
representation.
Circumvent.
In fact,
this writ petition has been filed
land interest taken over
by the petitioner Amit Kumar Niali. with a prayer for a direction to the opposite parties to make payment the amount of compensation as per the judgment and order dated 31/8/2023 passed by the presiding officer, LAR and R authority bracket ND bracket bracket ends comma Sambalpur in land acquisition case number 114 of 2020. It appears that the said case was a reference under section 64 of 2013 Act, which was sent by the land acquisition officer, land acquisition zone officer, Purda Road, Bolangir, for determination of the claim for enhancement of the quantum of compensation in respect of the land, which was acquired for the construction of Purda Road, Bolangir, New so project Bolangir. It appears from the order in portion that the court has held that the petitioner and the opposite parties number 2 and 3 are entitled to so and so operating the order ta dekhi lagi there. The learned counsel for the petitioner urged that in spite of such order passed by the competent authority, the payment has not been made, and therefore the direction may be issued to the opposite party number 1 for making necessary payment. Stop. Section 70 of the 2013 Act deals with form of award, and it states as follows, quote from the section 70. In view of such a provision for executing the order passed by the presiding of LAR authority in the Sambalpur, appropriate remedy is available to the petitioner. Therefore, we are not inclined to entertain this writ petition, and accordingly the same is disposed of giving liberty to the petitioner to seek appropriate remedy. Yes, next.
6, 7, 8 also same.
Same. There are case number olga na ko.
All case no.
I should have dekhi likhi.
Tarikh
order bhi olga hi.
Same date.
Same date.
Yes. One more thing.
Yes.
Tadre court dechi opinion ko chi land action zone officer Bolangi, that will Bolangi have a Purda court. That is both so both court.
Both ragam bulej.
That opinion number 1. Land action zone officer
Bolangi.
Bolangi. Opinion 1. It is Bolangi about instead of both.
Election the Bolangi election the opposite party number 1 to election the land acquisition zone officer Purda Road Bolangir news wants or said a both like the
that is Bolangi.
Oh, that is
all the
Bolangi Russia. अच्छा सी जो ये था opposite party number 1 who cooper like the land and counsel for the petitioner submits that inadvertently in the first title the party number 1 has been described as so, but the same should be so. But it's a both jagare Balangi. So the submission, the prayer, the oral prayer is accepted. It will be read as next.
I'll get it immediately. I'll go to the record.
No, upon should be interim application. I may call you read as Kolamanta.
That will solve. Yes.
Yes, next.
Item 14.
No, the Ketra matter chapter.
5, 6, 7, 8.
5, 7, 8. Next.
Item 14.
14.
The present petitioners annexure 1.
You are challenging the order dated 18/4/24.
Yes. Annexure
Past in.
OA appeal number 45 for 2021. The appeal memo has been annexed in Annexure 6. Annexure 6. Page 30.
Appeal has been preferred under which provision of the OE Act?
The appeal has been preferred, should be preferred under section 9 of the OE.
Come to section 9 first.
Yes. Appeal against collector order under section 3, 3B, 5, 6, 7, 8, and 8A. An appeal against any order of the collector, OA collector, under subsection 4, section 3B plus A, I, K, section 5, section 1, section 6 or 7, and subsection 3, 4, section 8A, he preferred within 60 days of such order the lie to Board of Revenue.
So now against this order, another appeal lies to Board of Revenue. This order has been passed by Sub-Collector.
Sub-Collector has no authority at all to entertain the appeal. That is my submission. So,
who has preferred the appeal? Who is the appellant?
Appellant is one of the villagers.
Part number 3 is that.
Annexure 6, page 30.
No, this appeal has been preferred by the appellant name is Nirmala Kumar Jena.
One of the villagers.
No. Here in the opposite part number 3.
Opposite part number 3. Annexure 6, appeal member.
Who are you?
I am the recorded tenant.
So you are not impleaded as party there?
Yes, my father was in, but during the pendency, he died.
Yeah.
No substitution has been taken place or no notice has been given to the legal head.
How can we know?
Yes, can you have that? That is my concern.
Where is the order sheet?
Yes. Can you have that? Annexure 5, the death certificate.
No.
Death certificate okay.
Death certificate ठीक अच्छी से मरी गले आप
order sheet देखो
page 39 annexure 9 page 39 पर
page
से उधर ना चलने का ना लिखा है
annexure 7 series 35
देना जेना
yes
केबे मल्ले पूछंती death certificate टा
22/5
22/5 okay. So you mean to say that the order was passed a dead person?
Yes.
No step has been taken.
Yes.
And can you not raise this point in preferring an appeal before the Board of Revenue, which you are is available on section?
No, OA case, it has been settled in my name. So any agreed party against that order can prefer the appeal. So Nirmala, who is deemed to so-called filing the appeal against the OA collector.
Are you not aggrieved by this order?
Yes, yes.
So you are an aggrieved party.
Yes,
Why
yes.
you say that an appeal is to be filed by the appellant only.
Because sub-collector has no jurisdiction at all.
That jurisdiction point, you can raise it before the Board of Revenue.
One thing. Second aspect is that let it be remanded. I have no objection.
No. That you have an alternative remedy. Why will entertain this writ petition? That is the main crux of the matter.
Jurisdiction at all. Passing the order.
That point also you can argue there.
On appeal under the sub-collector under so and so. And then
It's an appeal.
notation. Have you got the first title of that appeal memo?
Yes. Annexure 6.
Annexure 6.
Page 30.
We appeal number 45 of 2021. If you would have wanted to a mutation appeal, we appeal about it. Nirmala Kumar wants to Jena.
State has not challenged.
But that appeal was filed challenging the order passed by the respondent number 1 means Tahsildar.
Tahsildar OA collector.
Tahsildar OA collector order ta hochi 30/1/1985 against order
Should not have entertained, that's what he says.
Sub-collector to file appeal ta file eta under which provision this appeal was filed?
Having no provision at all. Before the sub-collector.
No. The collector definition re asuni ki eta.
Any option. Your lordship definition part your lordship see. Collector includes section 2E, 2D. Collector includes an officer appointed to the state government to discharge all or any of the functions of the collector under this act.
Where is the order dated 30th 1/85? Where is that order?
Yes.
Against which the appeal was filed?
Can you have an answer?
Yes. Where is
Back page.
Huh?
Back page. ROR back page.
Page number you just tell me.
Page 21.
Page
OA case number 162/85 dated 31/85. Hukum mutabak khata number 3.
Where is that order?
That order. The sub-collector is saying that the order is missing from the authority. That is also I have got it from RTA.
Where have you said that?
Yes.
Section 9 অনুযায়ী যদি appeal appealটা ନାଇଁ order ଯଦି ହେଇଥିବ collector pass କରିଥିବେ ତାହେଲେ appeal କରିବ board of revenue. ଯଦି proviso ରେ କହୁଛି if the order is passed by an officer other than the collector ତାହେଲେ भी appeal टा lie କରୁଛି board of revenue को but if the order is passed by the officer other than the collector of so then appeal is lie to the collector, like before the collector who shall dispose of the appeal, same procedure to be so provided the order is passed by an officer other than the collector, the district appeal if referred within 60 days of such order shall lie to the collector. What is the difference between these two proviso? Section 9 of dita jo proviso achi first main subsection 1 is very clear. Collector যদি order pass করিবে তাহলে board of revenue কু লাই করিবে ঠিক আছে যদি order টা any other officer other than the collector pass করলে
An appeal is
তাহলে
preferred
appeal
within 60 days
will lie to the board of revenue কইলে
It shall
first
dispose
provider
of the appeal according to the prescribed procedure.
পুনি second provider কହୁଛନ୍ତି same thing passed by the officer other than the collector of the district and appeal if preferred so and so lie to the collector.
Collector আস্থানে কোন হচ্ছে রেভিনিউ বোর্ড রাখলো সেকেন্ডারি কলেক্টর পাঠাই যদি কলেক্টর পাস করছি রেভিনিউ বোর্ড বুঝি that
That is explanation.
officer
Wait,
other than the collector of district they be
Same thing is stated in the second provider.
board of revenue other than the ঠিক আছে other officers order is passed by an officer नहीं দেখুন না ঠিক
Same thing কই যেরকম
by an
ফুটবল
officer by
প্রিন্ট হইছে না
হ্যাঁ বল
Where you say?
এটা সেম থিং না ডবল প্রিন্ট হইছে প্রথমে কইছি ফার্স্ট প্রোভাইডর কইছি যদি other than collector of lie করিব board of revenue কু পুনি গোটে কইছি other than the collector যদি ইয়ে করিব lie করিব
there is a typo
somewhere it is
Repetition. এতে পছরে যে লেখা হইছে যে সেকেন্ড প্রইটা দেখুন An appeal is preferred within 60 days for such as like to the collector who shall dispose of the appeal according to same procedure as is preferred for disposal of such appeal by the board of revenue. মানে এইটা সেই জিনিসটা সেই তরফ নাই
that means the if the appeal is preferred before collector the procedure is will be same
but here say three coach if other than the collector the board of revenue
some printing mistake is there in this book ତେଣୁ ଏଇ ଅର୍ଡର ଟା ପାସ୍ କରିଛନ୍ତି ସବ୍ କଲେକ୍ଟର କ୍ୱେଶ୍ଚିନ୍ ଇଜ ଦ୍ୟାଟ୍ ସବ୍ କଲେକ୍ଟର ଅର୍ଡରରେ ସେ କଲେକ୍ଟର କୁ ଅପିଲ କରିବେ ନା ସବ୍ କଲେକ୍ଟର ଅର୍ଡର ଏଗେନଷ୍ଟ ରେ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ କୁ ଅପିଲ କରିବେ
এইটা যে কোশ্চেন আসলা অপিল কেবল
কোটা
এই যেটা অর্ডার ইম্পর্টেন্ট সেটা অপিল এর অর্ডার হইছে
হ্যাঁ
তো এটি অপিল তো অলরেডি হিসে অপিল অর্ডার এগেনস্ট কোটি জস্ট নাই তা
অপিল an appeal against the order of the collector পাখরে যদি ম্যাটার জীব section 3b
that is not applicable here the proviso is applicable because of the fact that Tahsildar has passed the order against the collector the submission is that sub collector is not authorized
ବୋର୍ଡକୁ ଆସିବ 3b4 ରେ କଣ କହୁଛନ୍ତି 3b4 ରେ এটা তার ইম্পোজিশন অফ পেনাল্টি প্রভিজন রହୁଛି କଲେକ୍ଟର ର ଆ ଉପରେ on the intermediary ଯଦି ଫେଲ କଲା ଦେନ୍ କଲେକ୍ଟର ପାୱାର ଅଛି ତାକୁ পেনাল্টি ইম্পୋଜ କରିବ ଏବଂ ସେଇ ଅର୍ଡର ଏଗେନ୍ ଯଦି ପାସ୍ କଲା କଲେକ୍ଟର ତା ଏଗେନଷ୍ଟ ରେ ଅପିଲ ଲାଇ କରିବ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ହେଲା ଗୋଟି ଗୋଟି ପ୍ରୋଭିଜନ କୁ ଦେଖନ୍ତୁ 9 କୁ ଧରନ୍ତୁ ଗୋଟେ ଗୋଟେ ପ୍ରୋଭିଜନ ଅପିଲ ପ୍ରଥମ ଅର୍ଡର ଟା କହୁଛି 3b4 ର ଆଜ୍ଞା ସେକେଣ୍ଡ ଟା ହଉଛି 3b4 ଟା ହଉଛି କଲେକ୍ଟର ପେନାଲ୍ଟି ଇମ୍ପୋଜ କଲା ଇଣ୍ଟରମିଡିଏଟ ତାପରେ ଆସୁଛି 5 ର HIK. Five row HIK. So these are also the orders which are to be passed
Here,
by the collector. So
here section 6-7 is are invoked.
तापर which is section 6 row subsection 1. 6 row hala so on so on so.
After 7, certain other lands in khas possession of intermediaries to be retained by them on payment of rent as royals are coincided.
Here order to be collector class shall be determined rent etc. Tapraschi section 7. 7
Certain other lands in khas possession of the intermediaries to be retained by them on payment of rent as royals having occupancy right.
So
Collector.
এটা মধ্যে
determined by the
collector. এই order against মধ্যে ଯିବ appeal to board of revenue. ତାପରେ ବାକି ଆଉ ଗୋଟେ ରହିଲା 8 ର 3 ନାଇଁ 8 ର 3 and 4 ଦେଖନ୍ତୁ 8A ର 8 ର 2 3 ଆଉ 8A ର 3 4. 8 ର 2 3 ଟା କଣ any person will relate to so again determine the rent determination 3 and 4. Any person who immediately before the date of vesting held the land so on so. The date of vesting will discharge. A order against the collector class. Therefore, like 8 year of 3, 8 year of 3 and 4 clear. 8 year of 3 and 4 law. On the failure of filing the claim so on so. The case may was vested from. The collectors are prior to determination of the inquiry into the matter. So these are the orders which are obviously to be passed, and if those orders are passed under these sections, so the appeal will lie to the Board of Revenue. It's very clear now. Acha. Now this order obviously has not been passed by the collector, and collector definition explanation ne kouchi je additional district magistrate of the district. Bartaman e jo we appeal ro order ta pass korchanti sub collector which was preferred against the order of the Tahsildar. Tahsildar. So,
according to you, the order dated 30th January 1985 in OEA case number 162 of 85 has been passed under which provision?
8-1.
Yes, 30th January 1985 order passed.
8-1.
8-1.
Let us see that.
Pass for this.
8-1 any person who immediately before the date of vesting of an estate, the state government was in possession of any holding as a tenant under an intermediary shall on and from the date of vesting shall be deemed to be a tenant of the state government.
Deemed tenant.
Deemed tenant.
So then your submission is against that order.
Against that order,
Board of Revenue should have entertained the petition.
No.
That's what his case. He says.
This order is passed by the Tahsildar. appeal lies to so 8 যদি অর্ডারটা হেলা appeal লাই করিব বোর্ড অফ রেভিনিউ লাই করিবনি 8-1 against বোর্ড অফ রেভিনিউ লাই করিব কলেক্টর পাস କରିବ ପୁଣି 8-2 ଆଉ 8-3 ହେଇଥିବ ତାହେଲେ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ লাই କରିବ
2 and 3. 2 and 3. Just see now section 9. If according to you, if the order of 1985 is an order passed under section 8(1), then the appeal lies somewhere else, not the Board of Revenue. Then rightly entertained by the sub-collector.
That would be under the proviso. The second proviso টা কোন সেটা দুইটা হচ্ছে ভুলে যাই the second
But
proviso
collector has rightly done it.
collector সে সব collector ଦେଇଛି ବର୍ତ୍ତମାନ ସବ୍ କଲେକ୍ଟର ଯଦି ଅର୍ଡରଟା ପାସ୍ କଲା ତାହେଲେ
That against further appeal line. That against further appeal line, it lies. Merit only with given entity.
This writ petition has been filed by the petitioners Jayant Kumar Jena, Jyotsna Rani Jena, Usha Sri, now Usha Sri. Usha Sri. Usha Sri লেখা আছে টাইপ ভুলেছি তা যে না ভুলেছি না কোন পিটিশন নম্বর 3 র না দেখিলে
And that is right.
she লেখিছি Usha Sri.
No, right.
This is to be amended. Usha Sri লেখନ୍ତୁ ସେ ତାପରେ ଦେଖିବା and Jayashree Jena challenging the order dated 18/10/2024 passed by the sub-collector Kamakhya Nagar, opposite party number 1 in OEA appeal number 45 of 2021 under annexure 9. The appeal memo indicates appeal memo which has been filed under annexure 6 indicates that the said appeal was filed by one Nirmal Kumar Jena, comma, the opposite party number 3, challenging the order dated 31/1985 passed by the Tahsildar, Udia Tahsildar, Kamakhya Nagar, in OEA case number 162 of 1985. The Land Council for the Petitioner submits that since the order was passed by the Tahsildar in the OEA case, exercising its power under section 8(1) of the Orissa State Abolition Act 1951, an appeal was filed before the sub-collector Kamakhya Nagar under section 9 of 1951 Act, and since the same has been disposed of, there is no other alternative remedy available than to approach this court in the writ petition. Stop. The London Council for the petitioner submits that in the OEA appeal, the respondent number 2, Udayanath Jena, the father of the petitioners number 1, 2, and 4, and husband of petitioner number 2 was the respondent number 2, who died on 22/5/2022. No step has been taken for substitution by the opposite party number 3, the appellant in OEA appeal number 45 of 2021. And obviously, the petitioners were not arrayed as parties and no notice was issued, and principle of natural justice has not been followed while passing the impugned order dated 18/10/2024 in OEA appeal number 45 of 2021. Stop. In support of the contention, the Land Council for the petitioners has annexed the death certificate of Udayanath Jena. And the impugned order clearly reveals that the petitioners, who are the legal heirs, have not been arrayed as parties in the said appeal. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite parties number 1 and 2. So far as opposite party number 3 is concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter to be listed after 4 weeks. Counter affidavit any be filed in the meantime. IN number 5535 of 2025. There shall be stay of operation of the impugned order dated 18/10/2024 passed by the Sub-Collector Kamakhya Nagar under Annexure 9 until further orders.
Limited to status quo may be.
But status quo, we do not know. Stay you have prayed, we have granted stay. Yes, next.
Status quo has been paid.
Obviously it is stay. Notice has been issued and stay has been granted, so it that order can now implemented. Yeah. Yes.
Item 5, 6, 7, and 8, since you also please to discuss matter and certified copy of the impugned order will be supplied by subsidiary Xerox copy. That will suffice.
Certified copy of the
impugned order supplied by subsidiary Xerox copy. Again, that I'll
replace by
exhibition.
photocopy.
5, 6, 7, 8.
5, 6, 7, 8. Display of the certified copy mauchunti.
Original certified copy
No,
certified copy which they filed.
Certified copy of the impugned order.
Return the certified copy by replacing photocopy.
Oh, अच्छा.
Replace the certified copy by
It key dictation agent. Land for this one submits that the certified copy of the impugned order be returned to the petition, returned to him.
Replacing the
in all the four.
all the 5, 6, 7, Teacher.
Item 17.
Yes, case under the present petition occupying the government land madam on the annex of 1 madam. Case number 13, plot number 84 madam. Now the present petition is agreed with the notice issued by the Tahsildar on the annex of height madam, page 90. That notice issued by the Tahsildar on the basis of the letter. एतद्वारा आपण जातीय राजपथ कार्यालय पत्र संख्या 1116/19/2025 on the basis of this letter this notice has been issued that letter under annex 4 page 18 issued by the independent engineer NS division Cuttack.
कौन हेला कौन जातीय राजपथ अवरोध कर रखे
No this is not a this plot is not a road
No, they are now going to construct the road and you are unauthorizedly encroaching that.
May I submit page 18 annex of 4 This letter issued by the superintendent engineer NS division Cuttack, the allegation made by the one Bully Sahoo, which is also made as the party in this writ application, OP number 8
Yes.
That Bully Sahoo is the record of tenant of the adjacent plot of the 83. That is 84 plot. That is completely private land. That Bully Sahoo also trying to encouraging the 83 plot, my lord. I have also.
If you have got any dispute with that Bully Sahoo, institute a suit.
Yes,
and this cannot be adjudicated. This thing, disputed thing. We are concerned that a notice has been issued by the National Highway Authority that you are an encroacher.
That National Highway Authority issued this letter on the allegation of made by the Bully Sahoo.
Yes.
Page 18, please find the enclosed here with the petition by the Bully Sahoo regarding the encroachment of the government land. That Bully Sahoo also encroaching the land.
Not.
What is your case? She is encouraging, therefore I will
also increase.
That's your case.
And since long my lord encouraging. This Bully Sahoo is the record of tenant of a private land. They establish a hotel. Page 17, I will supply the photocopy. They creating the
and
trying to evict them with the hand gloves of the government.
The petition of Bully Sahoo is accompanied by the letter of the SC Cuttack R&B division and also a court order directing eviction. So everything was taken into account. That is why notice has been issued.
That court order also they are suppressing the fact that he is also encroaching the land.
For the land council, for the petition, land council for the state.
And by the
This application has
before the collector
filed by the petition for a to pass the notices under dated 19/3/2025 and 25/3/2025 under annexure 4 and 5 from the annexure 4 which is issued by the superintending engineer NS division Cuttack, also annexure 5 which is issued by Tahsildar Sadar Cuttack. It appears that the petitioner is an encroacher of the land on which the National Highway Authority is trying to make some construction, and therefore the eviction notice has been issued. So the Land Council for the petitioner submits that even some dispute with Srimati Bully Sahoo from opposite party number 8, at whose instance such notices have been issued. But we find that apart from the petition of Bully Sahoo, the notice also indicates the letter of the SC Cuttack R&B division Cuttack and the order of the court. And if the petitioner has any grievance against Bully Sahoo, he is at liberty to approach, seek remedy before the appropriate the Land Council submits that a representation is pending for the collector, Cutter, opposite party number 3, which is dated 26/3/2025, and the same may be directed to be disposed of. From the eviction notices, as such, we do not find any thing to interfere with. Therefore, we are not inclined to entertain this writ petition, which is dismissed. It is open to the petitioner to seek appropriate remedy in accordance with laws. Yes.
Dispose of.
Next.
Dispose what kind?
We are not inclined to entertain this. Yes. Next now.
Given the liberty to.
Item 18.
Yeah, that is it is open to you to approach.
I have already approached myself. Only that.
All right.
We recorded that also. We have recorded that. You have given representation.
Can we?
Only request my lord, file contempt petition against the collector, or yes, and that would be a ground to that I have approached the High Court, and the High Court has passed this order. So till that is finalized, I will not go anywhere. So I will stay unauthorized place on enforcing the national highway. Will not pass that order. Yes, next.
Item 18.
18 same also. All right, next.
Item 19.
My lord. My lord, the petitioner is a member of Indian Navy and applied for a residential plot in Bhubaneswar. He was allotted a plot on the basis of lottery, but he was totally, his service was throughout India, so he could not contact those authorities. So that was why then he has filed this, after retirement, he has filed this WPC 17097 of 2012, where the High Court on 1st November 2012 ordered that and instructed the opposite parties to complete the formalities of lease of the plot within 3 months. After that, he has approached the authorities, but they could not, they had not cooperated with him. So he again filed one writ 17995 of 2024, but it was withdrawn for filing a better petition. Today I am filing, I filed this, kindly admit it and yes or no to them so that I can get the plot.
No, come to the order which has been passed under Annexure 4. They are also petitioners. And if we come to the operative part of that order at page number 16, accordingly, please place that order. 16 page को आसंतु last portion टा पढ़ो.
Accordingly, we direct the opposite parties to execute the lease deed in respect of the land in favor of the petitioner on payment of present market value by him, with conditions that the petitioner shall construct his residential house over the land within a period of 3 years, and he shall not lease, sublease, or sell the land for a period of 5 years, nor shall he over the land to anybody for commercial purpose and for construction of apartments. Further, it is construction, if the construction is not made over the land in question within period, as indicated, the land shall be resumed by the state government. The formalities for execution lease shall be completed within 3 months.
So,
my lord, I have.
An order has already been passed. Why have you again approached this?
My lord, I have approached the authorities. They have not cooperated me.
No. What way you have approached?
You complete the lease within 3 months.
How can they complete unless you make express your intention that I am ready and willing to pay the present market value, and as for the order of the High Court, where is your application? Where is your application in terms of the order passed in the Annexure 4? ଆପଣ ଯଦି payment କରିବେ present market value execute ହବ.
I'm ready to pay the market.
ନାଇଁ ମୌଖିକ କହିଲେ ହବନି. ଆପଣ ଅଥରିଟି ଙ୍କୁ କୋଉଠି ଲେଖିକିନି ଦେଲେ ଏଇ ଅର୍ଡର ପାସ୍ ହେଲା ପରେ ଯେ ହାଇକୋର୍ଟ ଙ୍କର ଅର୍ଡର ଏଇଆ, ମୁଁ ବର୍ତ୍ତମାନ ପ୍ରେଜେଣ୍ଟ ମାର୍କେଟ ଭ୍ୟାଲ୍ୟୁ ଦବାକୁ ରାଜି ଅଛି ଏବଂ ଆପଣ ଲିଜ୍ ଡିଡ୍ ଏକ୍ଜିକ୍ୟୁଟ କରନ୍ତୁ. ଏଇ ଟାଇପର ଲେଟର
page number 12 annexure 3 my lord.
କଣ ଲେଖିଲେ?
ଯେ for plot number 68 measure 45/75.
Now what is the date of this letter?
Date is not, he has not.
The date is not given. ତାପରେ ଆଉ ଗୋଟେ ପଢନ୍ତୁ. I am unable to deposit the premium. So କଣ ମାଗଣା ସି ଆପଣଙ୍କୁ ଲିଜ୍ ଡିଡ୍ ଦେବେ କି? ହଁ, ହାଇକୋର୍ଟ ଅର୍ଡର ହେଲା, ଆପଣ ମାର୍କେଟ ପ୍ରାଇସ୍ ଦେଲେ ଆପଣ ଲେଖିବେ I am unable to ତାପରେ
1989 କଥା କହୁଛି ନା 1989 କଥା ଯାଇଥିଲା ମୁଁ ସେଇ ସମୟରେ ଦେଇପାରି ନଥିଲି ଯୋଉଥିଲେ କି ମୁଁ କେସ୍
present market value will even today if you do today's market value
I am ready man
not 2012
I am ready man
that period has been so this application which you have filed, you see that what is the how you have written it, that I have filed a case bearing number so and so for reallotment of the so and so. The Honorable High Court has given a direction to execute the lease deed in respect of me. Kindly look into the matter and allow me to deposit the demand amount against the allotment that it kebe kale.
Immediately se 2012 रे करा है
काई कोड जणा
कहीं देनी से मते जहां
and if it is submitted that there must be some documentary proof that such an application was submitted before the
I will give me a time I will definitely submit
ना आदिर लिखाई छि केबे देले ना आपण पाखरे एटा को हातेरे देले
मो ऑफिस कॉपी मगे दी मैं
हां हातेरे देले कि बाय पोस्ट रे पठेले कोन हेले सी फाइल कि नाही हां लेखन the writ petition has been filed by the petitioner Viranchi Kumar Dwivedi with a prayer for a direction to the opposite party number 2 to execute the lease deed as per the order passed by this court 1/11/2012 in WPC number 17097 of 2012. In the operative portion of the said order, it is mentioned as follows, quote, accordingly so and so. Though the petitioner has annexed an application by the annexure 3, wherein it is mentioned that he may be allowed to deposit the demand amount against the allotment of land as per the direction of this court, but the application doesn't mention the date on which it was submitted before the concerned authority, nor any documentary proof is available regarding the date of submission of such application. Needless to say, this court has directed in the order dated 1/11/2022 that the formalities of execution lease shall be completed within 3 months from the date of order. Therefore, the date on which annexure 3 has been submitted before the concerned authority is very relevant, and the petitioner has not filed earlier. You have not filed any application for contempt.
No, ma'am.
The land counsel for the petitioner has not filed. The petitioner has not filed any contempt petition for violation of the order dated 1/12/2012. And what is your explanation? Why have you approved this delay?
My lord, bypass.
What is the explanation part?
He was ill after that.
Where is the ground taken?
My lord.
Where is the ground taken that how you are explaining the delay of 12-13 years?
He was bypass surgery was there, and
where have you said that?
Still
Where have you said
ill now in the bed.
No, have you said that in the petition?
My lord, I have not.
Do the needful, otherwise that will go on ground of delay and laches. Look on the this present writ petition has been filed in the year 2025, almost after 12 years, and no satisfactory explanation has been offered regarding the delayed filing of this writ petition. Land counsel for the petitioner seeks for an adjournment, not only to provide us the documents regarding the date of application under Annexure 3, but also to in application for amendment of the writ petition, incorporating the indicating the grounds for delay in filing the writ petition. This matter after summer vacation. Yes.
Item 20.
Please on behalf of.
Yeah.
Occasion, my lord. In WPC number 29231 of 2024, my lordship has been pleased to direct the authority for consideration of my grievance order. That is order dated 4/12/2024, available to my lordship as page 22. Thereafter, the learned collector cum district magistrate has passed an order under at page 25.
Now you come to the portion page 26.
Yes, sir. Now, therefore, the undersigned has not found any evidence that the petitioner, namely Maruti Damo, was residing in the village D. Korol, where the ULIL company exists, or any record available that his or her house was there at the time of the notification of the land acquisition, and she has been paid any compensation for damage of house property. Therefore, it is concluded that she is not this person. Now, lordship may kindly have a glance at annexure 1, my lord, page 13, page 12 and 13. The acquisition notice and the demand draft they have paid in lieu of the compensation, my lord. To the petitioner on 13/12/2012. Now they are saying that no compensation has been paid. They have paid it. The Withdrawal Alumina International Limited, they have paid it. And I have received it. Notice was also issued to me on 25/6/2012. Thereafter, compensation was paid.
Which is the document you said?
My lord, page 12, under annexure 1, my lord, page 12. Page 12 is the notice, page 13 is the demand draft.
The petitioner, Malati Dambo, has filed this writ petition challenging the order dated 17/1/2025 passed by the Collector and District Magistrate Rayagada, holding that the petitioner is not a displaced person and she is not eligible for employment in the company. Which company is that?
Withdrawal Alumina.
Withdrawal Alumina. As per the Orissa Resettlement and Rehabilitation Policy.
Copy number 4.
It appears that earlier the petitioner approached this court in what is that earlier order?
My lord, that is under annexure 4, my lord, page 20, WPC number 29231 of 20.
In WPC number 29231 of 2024. Inter alia with a prayer for necessary direction to the opposite parties for extending the benefits under rehabilitation scheme as per the guidelines within a stipulated period. And since a representation was by then pending before the collector cum district magistrate Rayagada, this court file disposing of the writ petition as per order dated 4/12/2024 directed the so and so opposite party number so and so to take a decision on the representation filed by the petition within a stipulated time. The Land Council for the petitioner submitted that in the impugned order, it is stated as follows, quote, the now therefore to ye porjanta, है ना? He further submits that though it is mentioned in the operative part of the order while rejecting the claim of the petitioner that the petitioner has not been paid any compensation for damage of the house property, but the documentary evidence which are available under Annex 1 would show that the petitioner has been noticed by the Special Land Acquisition so and so on dated notice dated 25/6/2012 and the draft dated 13/12/2012 amounting to rupees 5,50,656 has been issued in the petition. Therefore, the conclusion arrived by the opposite party number so and so collector district magistrate is not sustainable in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite parties number 1, 2, 3. 1, 2, 3. Extra copies of the writ petition be served on the Land Council for the state. So far as opposite party number 4 is concerned, requisites for issuance of notice by speech of proof of bill will be filed within a week. Matter be listed after 4 weeks. Counter affidavit if any be filed in the meantime. Yes.
Item 21.
Come for intervention petition.
Right.
Who has filed intervention?
I filed my intervention application.
IA number 7641.
Yes, ma'am.
So intervener is Bajrang Bali RE Rollers Private Limited. So
this writ appeal, my lord, arises out of a common order. My lord, kindly see that order at page 42.
No, let that be allowed. I have no.
you have no objection.
No.
So just a minute. You are a party in that writ petition.
In the common order,
There is a judgment clubbing together all the writ petitions.
IA number 7641 of 2024. This intervention action has been filed by Messrs. Bajrang Bali RE Rollers Private Limited for impleading him as respondent number 4 in the writ appeal. Mr. Mahanti, learned counsel for the senior advocate appearing for the appellant has no objection to such prayer made in the interim motion. Accordingly, the prayer is allowed. The so and so is impleaded as opposite party of a respondent number. Respondent number 4 in this writ appeal. The land counsel for the appellant shall file a cause title, amended cause title by next week.
All right.
By next week. So this has come only for this purpose today. I yet dispose of it. Yes, next.
My lord, what I pray, my lord, in fact, I pray sorted for hearing. Otherwise, my lord, pursuant to the learned honorable single judge order, there has been a change in the, my lord, statutory framework. So
No, let him file this by next week. A copy of it will be provided to you, and then you make mention for the
hearing, my lord, prior to vacation, my lord, because now they are demanding the additional security deposit in spite of the order. That's my difficulty, my lord.
Nobody is against the early hearing of the writ appeal, provided that these necessary formalities be over by next week. So thereafter, file the application. Once you get that copy of that cause title amendment, you can file a memo so that appropriate order can be passed. Yes, next.
Interim order is there.
Interim order dated?
That is dated 27/7/22.
The interim order dated 27/7/2022 shall continue until further orders. Yes.
Item 22.
22, your lordship, notice has to be sufficient for opposite party numbers.
Mr. Gautam.
For A, for B, for D, return refusal. So that will be sufficient.
Substitution of notice on the substitution matter issued to R4A, 4B, 4D, written answer with postal challenges. The notice on so and so is written on with postal report refused. Therefore, it is held sufficient. So, baki au kaun rehna? The interim application number 61 of 2025. There is an application for substitution of the successor oblique legal heirs of the deceased respondent number 4 of Madan Jena. After hearing the land counsel for the parties and going through the averments taken in the interim application, the prayer out and the the parties named in the schedule, this shall be now added as respondents number 4 is so and so and amended cost title to be filed. File कर दीजिए ना करीबे करना थी वो amended by next week, है ना? And you are there in this?
No, I'm appearing for respondent number 3.
No, ठीक है.
I'm supporting his case.
No, ठीक है.
You are directed to add them as respondent.
हाँ, respondent number. See number का है. See जो number अच्छी 4 is 1 सा खाली cost title दा वो file करी amended cost. Yes.
Item 23.
Your Lordship, item 23 may be permitted to withdraw.
तो file कर दिया अच्छा हो जाए. Filing an interim application for withdrawal, the council has filed. Now you have filed the interim application. Sure. Instead of filing an interim application for withdrawal of this one, so the council has filed a memo. Look, the land council for the petitioner has filed a memo for withdrawal of the petition ତାକୁ ପଚାରିବ ଏଇ ଯେ ଡିଫେକ୍ଟ ଦେଖଉଛନ୍ତି ଷ୍ଟାମ୍ପ ରିପୋର୍ଟର ହେଲା ଯେ ହାଇକୋର୍ଟ ରୁଲ୍ସ ରେ ଅଛି କି ଯେ withdrawal ପାଇଁ interim application ଫାଇଲ ହବ ମେମୋର ହେଇପାରିବନି କହିବ ଡିଫେକ୍ଟ ଦେଖେଇଛି ନା ହେଲା memo is taken on record and the writ petition is disposed of as withdrawn. Yes.
Item 24.
Legal loss. Just a minute.
This CMFL application
କଣ ଗୋଟେ ଆସିଛି ତ order dated 10/3/25 କଣ ଆମର pointed out that there is delay of funds and however in the interim obligation of care has been made condoning the delay of funds. You file necessary amendment application for condoning the delay of obligation has already been filed and for the in the interim paragraph appointment has been taken that this court had order dated funds asking order in the writ of directing the petitioner to file case with judge for service of notice with the respondent with further direction the matter will be listed in the petitioner complied the said order and requisites were filed on sponsor. And that line counsel for the petition remain under the bona fide impression that the writ of appeal will be listed on sponsor as directed. Supporting documents have not been filed by the land counsel for the petitioner. With this interim application to substantiate the appointment taken in this paragraph regarding filing of requisites on 16/9, let the registry verify whether in the writ of appeal sponsor requisites have been filed when the petitioner filed. Action. Place a report to that report. Report again. Pursuant to the order number so passed in front. My request for the notice was issued. Neither a dean nor unsure. And subsequently they were filed fresh requisites peremptorily. The peremptory period from so so no fresh requisites was filed within the peremptory period. State of it was dismissed.
No, sir. Peremptory কথা বললেন previous peremptory order was passed. Initially, notice was issued mirrors.
And after you second time,
সেটা তো হচ্ছে সেই ডিফল্ট হলো স্যার जो peremptory order pass হলো that was during the period when the lawyers absent from work and an order was passed to file the requisites peremptorily. So that day he missed the list because he had the impression that he has already filed the requisites on on
ନାଇଁ ବର୍ତ୍ତମାନ ହେଲା କଥା ହଉଛି ଯେ 21/10/19 ରେ
ଆଜ୍ଞା
ଆଉ ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଲା
ଆଜ୍ଞା
ଯେ ଆପଣଙ୍କୁ ଫ୍ରେଶ ରିକ୍ୱିଜିଟ୍ ଦବା କରିବା ପାଇଁ ତ ଯୋଉଟା କି ଆପଣ ଆଡମିଟେଡଲି କମ୍ପ୍ଲାଏ କରିନାହାନ୍ତି
ନା
ଆପଣ ଗୋଟେ ଇମ୍ପ୍ରେସନ ରେ ରହିଲେ ଯେ ମୁଁ ତ ଫାଇଲ କରିଦେଇଛି 16/9 ତେଣୁ ସେଇଗୁଡାକ ଇଏ କରିବ ତ ଏଇ ଯୋଉ 21/10/2019 ରେ ମ୍ୟାଟର ଯେତେବେଳେ ଲିଷ୍ଟ ହେଲା କଣ ପାଇଁ ରହିଲେନି କଣ ପାଇଁ
ସେଟା ଲୟର said absent from court work. That was on that day there was a abstention by the lawyers from the court work and honorable court so much passed the order peremptorily.
Court ऐसे ground ନେଇଛନ୍ତି ଏଠି
ଆଜ୍ଞା
ଆପଣ ସେତେବେଳେ କଣ ପୋଷ୍ଟ ହୋଲ୍ଡ କରୁଥିଲେ କି ଆପଣ କୌଣସି ବଡିରେ ଥିଲେ କି ଏକ୍ଜିକ୍ୟୁଟିଭ ବଡି
ନାଇଁ
ତାହେଲେ ତ କରିନଥାନ୍ତି
ମୁଁ ନାଇଁ original my young friend Mr. Sinha was conducting the case.
କୋର୍ଟ ବନ୍ଦ କରିକିନି ଷ୍ଟ୍ରାଇକ୍ କରିବେ ତାପରେ କହିବେ
ଆଉ ତ henceforth ତ ସେ ସ୍କୋପ ନାହିଁ ନା ସାର୍
ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି
Maybe you also kindly look at paragraph 5 page 3 of the petition. By the order dated 12, the matter was directed to list on it. The requisites for issuance of filed on. Even though during the relevant time, lawyer had abstained from court, the petition counsel was not aware about the peremptory order dated 29/10.
କିଏ ଆଦେର ପକ୍ଷ କିଏ ସବୁ
The bank, only question is he has been dismissed from service.
नहीं नहीं ठीक है ग्राम्य बैंक नोटिस न कले कौन
नहीं नहीं अच्छा दिन my friend has appeared and filed his.
Objection filed below my supplied last time.
नहीं नहीं ground
That lawyers
merit ये क्यों नहीं मालूम
the lordship may say that paragraph 10 of
ये order टा non filing of requisite उड़ा impression ने रही ले होगा इटा वो recall ही जाओ तापरे merit रा कौन
अगर merit से बुढ़ा 83-year-old. Let him be satisfied that he has given an opportunity of being heard in the
CMA
to that judgment or lordship.
CMAPL number 324 of 2022. This yeah. IN number 147 of 2022. There is an application for condonation of delay. No. अच्छा आपण कहिथिले अमेंडमेंट फाइल करेनी कुए
sir amendment file हैला पर my friend has entered apparently.
No
नहीं
amendment after the order of amendment.
आपण जो डिले कंडोनेशन फाइल करछंती सेटा होची 881 दिन
आगे 997 979 days
हां 979 नो सेट पे आपण जो ऑर्डर टा होची 10/3/25 रे लिखाई छी दी लैंड काउंसिल फॉर द पिटिशनर सबमिट्स that he will file necessary amendment application to this IA for condoning the delay of 979 days. तेणु से application कहीं?
Sir, then I'm sorry, my lord, I had the impression lordships had wanted me to.
नहीं.
No, they in petition that sir.
आपनकर prayer अछि 881 दिन stamp reporter point of 979.
Yes, 979 days.
लेखन अच्छा सीटा खाली लिखि दो जो देजन in pursuance of the order dated 10/3/2025 the Deputy Register Judicial has placed a note wherein it is stated as follows. ये जो पेज इजा लिखा है फ्लैग डी रे अच्छी देख देवे राधे रे ये जो as per the order number so and so to peremptory period say dita paragraph upon titi do stop. Mr. Samanthral and counsel appearing for the petitioner seeks some more time to file the amendment application to the IA for condoning the delay of 979 days. Matter be listed on such answers if in the meantime the amendment petition is filed, the same shall be placed on record. Yes.
May you also take it on next Thursday so that I can file it on Monday.
अब फाइल कर दियो तो गोटे मेमो टे दे दूं पळे आसो सांगे.
Okay.
Yes.
Item 25.
Yes.
In this case, I filed a for IA.
I have not received my lord in this opposite party.
No. You are the petitioner.
Yes, no.
So you want to add some parties.
Yes, no.
IN number 7896 of 24.
Yes, my lord.
Whom you want? अच्छा इतने बड़ा लोगों को ऐड करिए क्यों चाहिए?
Substitution की मरी आई थी.
So why are you not giving a copy to him?
Copy some of it.
Just a state to copy the change. He will take up this matter next week. IN number 7896 of 2024. There is an application filed by the petitioner for impleading 3 persons as opposite parties number 20/02/2022 as for this said law. three-person lottery, the persons who's mentioned in this schedule as of parties number 2222. The copy of the interim application has been solved on Mr. Swine, learned counsel for the upon kapa appear.
Another IS flag 14.
No, sorry, opposite party number.
Number 9 to 19.
9 to 19. In court.
No, my lord. Opposite party number 9 and 13 to 19.
Upon kapa appear kurjante upper lepunati nali 9 and 13 to 19. He seeks some time to go through the interim application and prays for an adjournment. Release this matter. Next week, next week. Learned counsel for the state submits that he has received the copy of the interim application. I would have
Another flag 14 for deletion of option number 11. That she has died in the means. Died yesterday. 14.
तार की सब्स्टिट्यूशन दरकार नहीं
Died is less.
अच्छा लिखो आइए नंबर seven 897 of 2024. This is an application 2024 or 25?
24.
25.
25 लिखा है 24. 8 of correction करियो है ना? Then application for deletion of opposite party number 11 from the who stated to have died in the meantime and he sees issueless. Land counsel for the parties have no objection to such prayer. Accordingly, the name of so and so is deleted from the. So next.
IA 78096 is for addition of party.
No. 8 order pass 7897 of 24. 96. 96 addition of party. 97 deletion of opposite party number 11. Hala?
96 में भी dispose.
कोड़ा? 9. पहले कौन सुनला नहीं? पहले मुझे देखी next week रासु. बुझीवे आउ कौन की रहिले से माने तार legal heirs की नहीं सब बुझीवे से कहिवे आपण जे आपको कहि देले addition party से कौन blindly accept कर जीवे without taking instruction.
Requisites matter direction हेतला requisites for phrase.
Go through it will come next week. Yes, next.
26.
IA has been filed for modification of the order made. If the wife is the appellant and on my application the stay order has been granted and the stay.
No, this matter has been disposed of.
No, my lord.
Oh, pending.
Pending matter.
So notice has not been issued.
Notice was issued.
Who is appearing? Nagarnai, Smruti, Santoshi.
My lord. No, nobody has appeared, madam. That is preferred not
Notice made, notice has been made sufficient or not?
Yes, my lord. Proper address it was.
Just a minute. Let us verify. Notice issue hela as per order dated 19/12/2023. Right. So, and there was a specific direction that you are to file the requisites and okay.
Item delivered. It is delivered, madam. Track report is there. Flag B.
Flag B. Flag?
Flag B and flag C. Tracking
Or track consignment. Achha.
Item
Consignment delivered. Item received. Item received. Achha. Notice sufficient. Ada kon matter kon? Matter da?
Matter the decree of divorce has been granted by the learned family court. The divorce application under section 13 was filed by the husband and that has been allowed. And the two aspects of the
So
judgment.
you are challenging that order.
My lord, that
So
order
why
dissolving the marriage solemnized between the parties.
ଆପଣ ପକ୍ଷ କାହା କରିଛନ୍ତି ମ୍ୟାଟରରେ?
Husband, he said the opposite respondent number 2 is a formal party. There is no connect. The allegation is that the appellant number 1
No,
was
it's all right, but at least opposite party respondent number 1 should have appeared.
my lord,
Tracking report.
his husband is the respondent number 1. The number 2 has contested the proceeding. No, they are not contesting. He is not the contesting. That is there.
Whatever Asuchi item received relief, it is to be held sufficient. What modification you want?
Modification, but there are two aspects of that.
19, 12, 20,
that
23
maintenance part that has been 15 lakhs that has been awarded for the maintenance of the song. That part may be excluded from that stay model because we are not able to, he's not paying anything because has been held by the London Trial Court that the wife will be not entitled for maintenance.
Impugned judgment will remain stayed till the next date of hearing.
Only that part of the judgment,
Just
the maintenance part.
What is the in the operative part? What has been held?
The operative part, my lord, the marriage between the petitioner and the
operative part. Who page rachi?
Page 49, running page 49. The petition is allowed in part on consistency respondent 1 and 3 and the expert against the respondent number 2. The marriage between the petitioner and the respondent number held on so and so is hereby dissolved. Rupees 15 lakhs only being by the petitioner as one-time settlement amount to the respondent number 3. That is the child support alimony within 3 months. My prayer is that this part may be order may be modified so that I can execute this part of the order at least, because nothing is being paid by the husband. Are you not seeking enhancement of that? My lord?
Enhancement you are not seeking?
Not seeking, because I am seeking maintenance for the wife, so that part I am not seeking.
ନାଇଁ ଏଇ ଯୋଉ 15 ଲକ୍ଷ ଟଙ୍କାଟା ଯୋଉଟା ଆମ ଆପଣଙ୍କ ପିଲାଟା ପାଇଁ ଦିଆଯାଇଛି ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 3 ଥିଲା to be given to the respondent number 3. 3 ଟା ହଉଛି master ex okay ଠିକ ଅଛି ତ ସେଇ portion ଟା stay କରିପାରିବନି you are right. Notice the sufficient ହେଇଗଲା IN number 72 of 2025. This is an application for modification of the order dated 19/12/2023. Stop. The Land Council for the petitioner submits that in the operative portion of the judgment and order dated 28/7/2023 passed by the Learning Judge Family Court Khurda in civil petition number 41 of 2023, apart from allowing the petition filed by the respondent Smruti Santosh Palai for divorce and directing dissolution of the marriage, further order has been passed for payment of rupees 15 lakhs by the respondent number 1 as one-time settlement amount to the opposite party number, sorry, appellant number 2. And since by virtue of the order dated 19/12/2023, passed in IN number 311 of 2023, the impugned judgment has been stayed till the next date of hearing, the appellants are unable to execute that part of the order, and therefore the order number 1 dated 19/12/2023 be modified to the extent of recalling this order so far as payment of rupees 15 lakhs by the respondent number 1 to the opposite to the appellant number 2, considering the submission made by the learned counsel for the petitioner appellants, and going through the averments taken in the interim application, the order dated 12/2023 is modified to the extent that the impugned judgment so far as impugned judgment except the direction of payment of the rupees 50 lakhs to the opposite party number 2 as one-time settlement by the respondent number 1 shall remain state.
Service sufficient.
Service, so we use the postal tract consignment report, which indicates that the notice has been made sufficient on the respondents number 1 and 2. None appears for the respondent. The notice is held sufficient. None appears for the respondent.
Posted for hearing. Posted for hearing.
Acha. No, it is just in IA has been, the order has been passed in a IA, but it has not been, that trial court record has not been called for, as it appears. In main application, the trial court record be called for, and matter be listed for hearing.
Specialization.
Matter be listed for hearing. Summer vacation for court of couch.
Modification.
Since this interim application has been directed to be listed before this bench by the Honorable Chief Justice, matter this one also to be listed for the assigned bench as per the order of the Honorable Chief Justice.
Only because the IA has come. before this bench.
Only for I, that's all.
Sure.
My lord, item 27 next. I may be allowed for consolidated amendment petition. Only amendment petition I see. I have filed. I have given the order copy. So
What is that IA?
I have given the OSS case number 1255/2022 additional commission revision 4. It was rejected. So I have filed that. So I want to file the amendment petition now.
No. What is the IA 6108
Yes, my lord.
of 2025?
25.
What is the amendment? What is the schedule of amendment?
I have given 1A. Schedule A.
Schedule টা ওটা ভিতরে কেমতি পুরে দিছে?
Schedule A I have written.
Schedule এটা প্রেয়ার পরে রইব না তা ভিতরে পুরে দিছেন?
ভিতরে পুরে দিয়েছেন।
কোনটা আড করিবে?
ମୁଁ ଏ ରିଭିଜନ ପିଟିସନ ଟା ଇଏ ଯୋଉ କରିଥିଲି ସେଟା କପିଟା ଦେବି ଆଉ କିଛି ନାହିଁ। amendment petition ଟା କରିବି।
କେମତି ଆପଣ ଏମତି ଲେଖିଛନ୍ତି ସେଇଟା ଗୋଟେ schedule ରେ ହବ ଏଇଟାକୁ ଆଡ୍ କରାଯାଇ ଯିବ annexure 7 ଏଇଟାକୁ annexure ଏମତି କାହିଁ ସେ ପ୍ରେୟାର କାହିଁ ଆପଣ
Annexure 8 in the consolidated petition, page number 36 to 34, Okalatan number page 45. I have written. Annexure 8.
In the consolidated and Okalatan number?
Page number 45. 36 to 34, consolidated petition. I have written it.
Your writ petition is having 6 annexures.
Yes, ma'am. 7.
Annexure 6 by लिखा है। देखिए।
Again, one amendment was there.
Consolidated.
Amendment there. So after that it's.
सादरे 7टा annexure ଅଛି। एटा को annexure 8 हो।
8 करो।
So, madam, have you gone through it? Any objection? Who is the opposite parties? He wants to just another order.
Another order of the
Lord, IA number 6108 of 2025. There is an application for amendment. The paragraph किसी add होगा ना खाली से order टा हुई।
खाली order टा
कोठी माने आज आना ता विषय राव किसी लेखा लेखी दरकार नहीं writ petition रे our या कहू छु परा ता विषय रे प्रेयर पोर्शन ने कि आपनकर writ petition averment रे से order टा आपन के against जाई कि ना नहीं against जाई कि खाता ऊपर इधर कोन कौन लिखि देबी नहीं you withdraw this like on IA number on the interim application to file a better one है permission is granted sure
item number 40 and taken up tomorrow
सब ई जहा रहला नेक्स्ट काली गेस
हां गॉट इट
In that case, the status order is there in that case, so interim order may continue. Item 25, man.
Earlier list, morning list is interim order to continue.
Item number 25 के dictation में थला यदि interim order थी बहुत
interim order
yes.
Supplemental list, item number 1.
Please, my lord. My lord, here, the appellant petition is also languishing in jail custody since 2013, more than 12 years in custody. My lord, that is against the order passed by the Lord Additional Session Judge Jaipur, convicted the appellant under section 302, 201 and also the 506 of the IPC and also sentenced to undergo the imprisonment for life. my lord, only basing on the solitary witness, that was the only wife, was also the incident was also occurred, that was, my lord, 16/7/13, and also the FIR has been lodged after 10 days.
Your bail application has never been rejected earlier.
No, never.
In this case, my lord directed to obtain well-being of the children and a custody certificate. The accused now not in Koraput jail. Custody certificate as per nahi, well-being ta as
It appears from that trial court record final form में या देखूची he was taken to custody on 28/7/2013. Final form to देखना final form रे page 3 देखो page 3 रे लिखा है date to which forwarded to court it is 28/7/2013. Trial court record order sheet to देखूची trial सरिया पर्यंत he was never granted bail. बाकी एठी हाई कोर्ट रे ताकू बेल मिलनी तेणु जहाँ जाइथो एमती ये रे जाइथो सो ही इज राइट दैट कस्टडी सिंस 2013 माने 11 वर्ष पाखापाखि 11 वर्ष ऊपर रहनी कौन एविडेंस कौन
PW7 and Dr.
PW7 is the doctor, 6 is the wife. And incident occurred, my lord, 16/7/2013.
Wait.
Sir, FIR has been lodged 26.
हाँ से भय करी पड़ेला लुची ता
ठीक है
PW6
committed murder of Vijay Mundo Gudia.
His son.
Oh, you are the father.
Yes.
Achha, why you
suspected his
suspect paternity was suspected. The allegation, that was the allegation.
PW Kapu evidence.
PW6 my lord.
6 was eyewitness.
Yes, the wife. He's the wife.
Wife of the accused. Accused Udhav is my husband. We are blessed with the 4 children, out of whom the last one is dead. My last child was male one. My last child died within 1 month of his birth. Last year in the month of Asadha, on the Thursday at about midnight, my husband accused him destroying his paternity over the last male child, killed him by pressing his throat in my presence at home. The deceased child was called in the name Vijay. That child was killed by accused within 1 month of his birth. Next, my lord, PW. Doctor. Paragraph 2. The cause of death of baby occurred due to asphyxia, which was further due to throttling.
The duration of death.
Duration of the death of PM examination was within 10 to 12 days, my lord. In this case, what happened on the next day morning, the wife out of fear away, stayed with his relation's house, intimated his parents. They come. Thereafter, affair was lost. By then, the accused already buried the dead body with the help of other.
All the villagers also.
Occurrence took place on 16/7, and the affair was lodged on 26/7. And if the child was buried, then how the postmortem was conducted? Thereafter, it was exhumed.
Yes.
So why your wife will tell against you? What is the reason? If will tell against you.
And my lord, the PW2 said that the death was due to his sickness, and the entire villagers, including the PW2, they have also taken
that is
the.
not acceptable because of the
PM report.
That it is a case of throttling, and the
which corroborated with 6.
The evidence is medical evidence corroborates the ocular evidence also. What is this instruction you have received?
Instruction mandate, wife married another person, and now children are staying in the village.
Wife को ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ ଆଉ ଆର ଛୁଆ ହଉଛନ୍ତି ଏମାନେ କୋଉଠି
ତିନିଟା ରାଜେନ୍ଦ୍ର
ତାର ମେନ୍ ଗ୍ରିଭାନ୍ସ ହେଇଥାନ୍ତା ସେଇ ଯୋଉ ଯିଏ ତା ବିରୁଦ୍ଧରେ PW6 he has already got married no
Married and staying at
Hyderabad.
Telangana.
Chanchola.
The children are staying with their grandfather and grandmother.
Or the land council for the petitioner, land council for the state. The land council for the petitioner submits that the petitioner was taken into judicial custody in connection with this case on 28/7/2013. And though the conviction of the appellant is based on the solitary testimony of PW6, who is none else than the wife of the petitioner. The land council further submits that in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Land council for the state, as per the order dated 13/2/2025, has produced the report dated 24/4/2025 of the IIC Boipaliguda Police Station, which inter alia indicates that wife has married to another person and staying at Hyderabad. The instruction is taken on record. Land council for the state further submits that evidence of the eyewitness PW6 is getting corroboration from the medical evidence adduced by PW7, the doctor who conducted post-mortem examination and opined that the cause of death of the deceased baby was due to asphyxia on account of throttling. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody for more than 20 years and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Line video. He further submits that counsel for the petition that there is no chance of early hearing as paperwork has not been prepared. As yet. Bail allowed. Yes.
Item 2.
Yes, so what is the surrender certificate?
Surrender certificate already filed along with IN number. IN number 887 on 21/3/2020.
It is stated by land counsel for the appellant that the surrender certificate has been filed with IN number
887
of 2025 on
21st March.
21st March 2025. Let the same be placed on record. Put
And
of
I
this
also
matter.
obtain instruction regarding conduct of the
Land and Council for the state has produced the report received from
IIC Barco.
IIC Barpur Police Station, dated 24/4/2025, which indicates that there is no adverse report against the against the appellants, and they have not violated the terms, condition of the bail, and they surrendered before the trial court on 4/2025, and now in jail custody at special sub-jail Devgad. The written instruction is taken on paper. Yes. Yes.
And technology.
Who will be Yes.
Item 3.
Yes, item 3.
Well, item 3. Disciplinary custody since 4/6/2013. Section 302, life imprisonment.
Custody certificate आएंगे कितने वर्ष हुई
सुंदरगढ़ जेल
Are you rejected la merit रे?
No, man. But interim bail was there.
On पे interim bail दिया था
मतलब
on पे interim bail दिया था
तो screen और there था
I should have to verify change. And number 1, that's the key.
That's the key, sir.
Queens will be as so how many appellants are there?
2 appellants.
So that means number 2 has never been released on bail.
No, man.
You bailed a file person
Both.
Both. Period হলো 6 বছর 6 মাস 10 দিন
Till now, 11 years, near about 12 years.
এটা কোন জেলার এটা সুন্দরগড় আউ তা পূর্বରୁ করছিলেন
না তো করতে
आस्था जो अच्छे से पैसे भागीरथी के सामने सेकंड का 10 सर्टिफिकेट हाँ दीटा अच्छी कस्टडी सर्टिफिकेट
हाँ
आस्था अच्छी
भागीरथी रहुची 2 वर्ष 8 मास
आगे
8 मास 18 दिन अब 11 वर्ष 12 वर्ष कोड हैला
ये एक्चुअली मझिरे इंटरिम बेल थिले 3 वर्ष 6 मास पुनी गोटे पैरोल ले जाइतले 1 year 11 months फॉरलोरी 2 months एमती टोटल देखलो
इंटरिम बेल 3 वर्ष ना
लेखा जी 3 years 6 months दैट इज योर
आपण कस्टडी अंडर ट्रायल ले आपण गोटे ता ना होची भागीरथी 5/6/2013 रे अरेस्ट हेले कस्टडी गले 5/11/2013 रे बेल आउट हेला तापरे ट्रायल पर जेतले कन्विक्शन हैला 18/4/2017 ठू ए पर्यंत सेटा होची 7 वर्ष 1600 एटा रहिसेंती किंतु इंटरिम बेल पीरियड सब रही तादेरे 3 वर्ष 6 मास पैरोल नहीं 1600 एक्चुअल कस्टडी पीरियड होची 2 वर्ष 3 मास
दैट इज आफ्टर कन्विक्शन
हाँ
एक्चुअल पीरियड आफ्टर कन्विक्शन 2 years 3 months 18 days
तेणु टोटाल पीरियड टा होची 2 वर्ष 8 मास 18 दिन 12 वर्ष 13 वर्ष
अरेस्ट
पर्यंत बेल ले जाइछन ना आपण 2 जन जाक बेल ले थिले 5/11/13 आपण कस्टडी ट्रायल कोर्ट रेकॉर्ड अछि जना पड़ियो
non-solution of the charge there we default. Okay.
Which persons are absent on call? ଓକିଲ ଆପଣଙ୍କ ଷ୍ଟେପ୍ ନେଉଛନ୍ତି। ଓକେ, ତ ବାକି ରହିଲା ମେରିଟ୍ କ୍ୱେଶ୍ଚନ୍।
Terminal possible.
Want to verify.
No, sir, I'll verify.
Verify ଆପଣ ଜେଲ୍ ର ଇଏ ଆପଣ ତ verify କଣ କରିବେ? There is no question of verification. It's a document which has been obtained from the jail authority.
That is true.
So, if you want to say something on merit, you may say, otherwise.
3 eyewitness card.
3
eyewitness. Informant, my lord.
All are the
PW
relatives of the deceased.
Relative
PW 9, 11, 13. They are the eyewitnesses.
Just a minute. Single model or double model?
Single.
PW key eyewitness?
9, 11, 13.
9, 11, 13.
11 is the child witness.
Just a minute. Eyewitness. Doctor key?
Dr. my lord.
PW 10.
Now on deceased one?
This is my lord Debanand. This Debanand. Informant.
Debanand is informant. Dayanand is the deceased.
Joyananda. Joyananda.
ठीक से कौन?
Joyananda Kisan is the deceased.
Dayananda.
नहीं
Dayananda.
PW गोटे का को आसम PW 9 की टोटल पड़ा है 11 हाउस वाला 11 प्लेस पर
The child witness.
But I will place now.
Forum.
But I am in the court here. तुम्हें कोड ऐसे the informant Debananda Kisan is my paternal uncle. The deceased Joyananda is my father. I know all the five accused persons standing in the dock. In the evening of 2/6/2013, at about 7:30 p.m., hearing hula of my father and mother outside, I came outside the house and found the accused persons assaulting my father near the clubhouse of our village. I, along with my aunt, Badamama PW9, rushed to the spot. I saw the accused Bhagirathi assaulting my father by means of an axe and accused Dasarathi striking my father by means of an iron pipe. Despite of our requests, the accused persons kept on assaulting my father. To rescue my father, I pelted a stone at accused Dasarathi, which hit his head, and again I pelted a stone at him, which hit his hand. My aunt PW9 and mother threw sands aiming at the accused persons, and thereafter the accused persons left the spot. When the accused persons, namely Dasarathi and Bhagirathi, were assaulting my father, the accused persons, namely Raina and Ukiya and Pancha, were instigating them by shouting as Maramara. Seeing our co-villagers approaching the spot, the accused persons left the spot. The alleged assault on my father was clearly visible to me due to the glowing of an electric light of the clubhouse. During the assault, though my father fell down on the ground and was writhing with pain, but the accused persons, Dasarathi and Bhagirathi, kept on assaulting him.
In this process, they have stated that.
In the prosecution, my lord, it is a fact.
So this is for both of you assaulted, one by axe, the other by iron pipe. And the eyewitnesses are there, and the doctor PW10, he has also noticed injuries, lacerated wound भी देखी थी और incised wound भी देखा.
Yes.
And he has given his opinion that which are the injuries which can be caused by hard and blunt weapon, and which are the injuries which can be caused by the death of the deceased is homicidal, and cause of death was shock and hemorrhage, injury to brain. Iron pipe or iron axe ମଧ୍ୟ produce ହେଇଛି ତା ପାଖରେ paragraph number 6 ରେ. Now she finds question.
There is no blood stain. There is no blood stain in the axe.
It was recovered at your instance.
Yes, yes, PW7 is the witness to the 27th of April.
And whatever my learned from Secretary 11, he has stated that I cannot, that it is a fact that by the time my arrival at the spot, my father had already fallen on the ground.
70. Leading to this 70.
And I cannot say for how much time the accused person went on assaulting for other, but neither myself nor my aunt had shouted together my co-villagers at the spot.
Criminal antecedent instruction.
There is my lord motive that they are selling liquors. As they have a impression that the president.
How किसी ये 2 वर्ष केते मास एगुडा आउट देखिया समर वैकेशन for a take up for put up this matter after summer vacation. The learning council for the state has produced the custody certificate which have taken on the record of both the appellants. When a query is made to the learning council for the state about the criminal antecedent, if any, against the appellant, he seeks some time to obtain instruction on the same. Put up this matter after summer vacation. Yes.
Item 4.
Madam, for your timely information, knowledge that we have filed a bail application, regular bail application in Supreme Court, and that is pending for 13 May 2009, 25 to be decided.
You want adjournment of this matter?
No, we want the interim bail.
Yesterday, you also they have mentioned that his brother has expired. For that purpose, your lordship has directed us to obtain instruction and on the memo that has been listed.
No, if your bail application is pending for consideration the Honorable Supreme Court, then why will we consider? We file appropriate application there.
It is for interim bail.
Your bail application was rejected on merit.
Yes.
And against that, you have approached the Honorable Supreme Court.
But my main accused has been granted regularly.
You take that ground, you must have taken that ground. So the matter is now sub judice in the Honorable Supreme Court. So why will you grant you bail? Whatever your ceremony, do it inside the jail and on the date which you say that they will take you and also on that day.
So on the date of funeral, he went.
Funeral तो over ही करानी माने
ଯାଇଥିଲି 5 घंटा ପାଇଁ
ଯାଇଥିଲ ତ ଆଉ ଯଦି ନ ଯାଇ 11 ଦିନ ଯଦି ଯିବାକୁ ଚାହିଁବେ ସେ ଟାଇମ୍ ଥିରେ କରିକି ଯାଆନ୍ତୁ ସେ ଯାଇ IA number 1176 of 2024. This is an application for bail. It is the London Council for on the ground of death of the brother of the petitioner. कितने नंबर आई है सेटा? 1176. The ground of death of the elder brother of the petitioner. Stated to have expired on 21st April 2024. The London Council for the state has received instruction from the IAC Titlagot Police Station dated 23/4/2025, which indicates that though the elder brother of the petitioner has expired on 21/4/2025, but the petitioner attended the funeral ceremony after he was brought to his native village on the strength of custody parole and instruction is taken on the call. The learning counsel for the petitioner submits that the bail application of the petitioner was rejected by this court as per order dated
6th November
2024, and challenging the said order, the petitioner has approached the Honorable Supreme Court. In view of such state of affair, we are not inclined to release the petitioner on interim bail. It is open to the petitioner to make necessary application before the jail authority for parole to attend the obsequious ceremony of his elder brother, which should be considered in accordance with law. Yes.
Apparently, connecting case on behalf of Chandan Samant, right? I'm also, I want to withdraw the I.
Which I want to withdraw?
Oh, I was pending. Connecting case, I.
कितने number तक होना? IA number 1693 of 24 तो?
Yes, sir.
Interim bail तक withdraw करिए जो चाहिए.
हाँ, already release on bail.
ठीक है जी.
Second I 1097 where it is a petition.
That appropriate order कौन रहा है?
सेटा सुप्रीम कोर्ट ऑर्डर केला पर सेटा ऑर्डर टा ये करे पे ऑर्डर टा सुप्रीम कोर्ट ऑर्डर टा को माने तळ कोर्ट ये करिया पे सेटा फाइल इतला आई फाइल इतला
कौन चाहूं चली बता
ऑलरेडी
so both he want to ask. ठीक है जी, देखो number 539 of 2017, the learned counsel for the appellant seeks permission to withdraw the two interim applications, that is IN number 1693 of 2024 and 1097 of 2025. Both the interim applications are disposed of as not placed. Yes. Next. And memo to that effect has also been filed for them. Yes. Next, item 5.
Item 5.
Your Lordship, on behalf of Women's Hon'Ble, the appellant is in custody on the date of arrest, that is 24th March 2012. And has been sentenced to undergo life imprisonment under section 302. And is based on circumstantial evidence.
Already, yellow. Premature release. Let's jump. CRLA number 690 of 2017. We use the letter dated 26/11/2024 of the Superintendent Sub Jail Deoghar, which indicates that petitioner has been released prematurely as per the order of the Government of Odisha Law Department by memo number 16551 dated 25/11/2022. The said order has been annexed to the later of the superintendent. Accordingly, the CRL is disposed of. If the appellant intends to challenge the revision, he can file an interim application to recall the order for the hearing the criminal appeal on merit. Yes.
Item 6.
Also, on the last two occasions, Lordship has directed us to give name address to local sureties. The petitioner is unable to furnish local sureties. Lordship may direct the matter may be listed in hearing list, my lord, any day next week.
Therefore, is there. Land counsel for the appellant took time to furnish the names, addresses, and documents of two local sureties who are interested to take him on bail. As he is a man from appeal memo jail criminal appeal या ना कौन जयप्रकाश वर्मा alias सिकंदर औरंगाबाद ना औरंगाबाद बिहार. The Learning Council for the appellant submit that the appellant is unable to arrange the local sureties, and therefore appropriate order be passed for expeditious hearing of the jail criminal appeal, since paper books have already been prepared. You have received the copy of the paper book?
No, ma'am.
Stop. You have received the copy of the paper book?
Only copies, paper book. Only deposition copy book.
Let the copies of the paper book be supplied to the Learning Council for the appellant, so also the Learning Council for the state matter state after summer vacation to do second week out of the year for hearing. Yes.
In item 7, my lord.
Item 7.
In item 7, my lord, 2 weeks time may be granted to file the surrender certificate.
No, whether he has surrendered or not.
He has surrendered, my lord. I couldn't get the certified copy. I will
The Learning Council for the appellant submits that after availing the interim bail period granted as per the order dated 27/11/2020, IN number 192 of 2024, the appellant has already surrendered in the trial court, and surrender certified copy has been applied for, and some more time may be granted to produce the same. Put of this matter, give some time to each time. Yes.
Item 8.
Yes,
May I please you, Lordship? Yeah. My lord, I have been in the jail since for last 10 years for on the 302 for killing my wife. There are only 2 eyewitnesses who are my daughter. One is 13 years old, another is 7 years old. And both are
who are the eyewitnesses?
PW15 and PW16.
PW15 and PW16 are the 2 daughters.
My lord, my own daughter, one is 13 years old, another is 7 years old.
Acha.
And I
Doctor.
Who
has conducted PM?
20. Doctor 20.
PW20 PM. PW20. So name of the deceased?
Name of
Nehalaka Pradhan.
Pradhan. Snehalata Pradhan,
Snehalata Pradhan.
you are an advocate or? No, he is not in the band, that's why I asked him. So Snehalata Pradhan is the deceased and he is the wife of
The petitioner.
So how you killed your wife according to your daughters?
But both of us are sleeping in the one room, and in the night when there was some doubt, they saw that I have killed her by the iron rod.
Akshay Kumar Beura was the state counsel earlier. Why he was engaged as amicus curiae. Right, yeah. ସିଏ ତାଙ୍କୁ ଏଥିରେ ଏବେ ଏନଗେଜ କରାଯାଇଥିଲା amicus curiae ପାଇଁ ତାଙ୍କୁ କୁହାଯାଇଥିଲା ଯେ interim application copy ଦବା ପାଇଁ because ସିଏ ତାଙ୍କର contact details ପାଇଲେନି ସେଇଥିପାଇଁ ସର୍ଭିସ କଲେନି ଫୋନ ନମ୍ବର ଯେ ଥିବ ତାଙ୍କୁ ଟିକେ ଇଣ୍ଟିମେଟ କରିଦିଅନ୍ତୁ ଲିଷ୍ଟ ମିସ୍ କରିଯାଇଛନ୍ତି ତାପରେ ଆସିକିନି ରିସିଭ କରିଦେବେ interim application for bail ଆଉ stay realization of fines ହେଲା ଲେଖନ୍ତୁ non appears for the learning amicus curiae. Mr. Akshay Kumar Beura is not present. The office has pointed out that the copies of the interim application could not be served on him as his contact details could not be found. Stop. Land counsel for the state submit that he will intimate Mr. Beura about the listing of the matter, so that he will collect the copies of the interim application from the registry. Put up this matter after summer vacation.
Item 11.
May I please, Your Lord? My Lord, here is offense number 302-307. The accused has been convicted for like malice.
Whether your bail application was earlier rejected?
My Lord, bail application was but then not in this appeal. Prior to filing of this application, the matter also will be tried.
No, in this criminal appeal,
Yes,
this has been
first time it has come up.
Huh?
It has come up for the first time.
First time.
He is inside the custody more than 7
Have you
years.
received the deposition copies?
My Lord, my Lord.
Okay. So what is the prosecution case?
My Lord, here the case is that there is no direct material available against the petitioner, the appellant. He is on the basis of circumstantial evidence and conscious confession. He has been convicted. There is no eyewitness.
Come to paragraph number 2 of the judgment.
Yes. May I read one?
Yes.
Prosecution case in brief is that the informant one Patrik Minj, a village, Kahapani, PS Putra, appeared before IAC Hemgir, PS, on 26/12/2017 and lodged a written report to the effect that he works as a driver in GBS company and for last 9 months, he along with his family, with his wife, Nandia Minj, daughter Suti Minj.
Nandia is the deceased.
Yes, my lord. Yeah. Nandia and Suti, Suti
Achha, it's a case of double murder.
Yes, my lord. Mother and daughter. And son Surat Min is staying in the house of one Matwal Tilki, a village Tiklipada, on rain. And as usual, on 25/12/2017, he went to his duty at 5:30 a.m. and on the same evening.
Surat Minj has been examined.
No, he is a minor. He is a minor.
No, examined or not?
No, he is not.
Because the allegation is also that there was an attempt to commit his murder. So he would have been the best witness. Okay. Then,
my lord, he went to his duty 5:30 a.m. My lord, secondly, 5:30 a.m. and on the same evening, 5 p.m., he talked with his wife to the phone of his neighbor, Ajub. And at 5:30 p.m., the accused came to the house of Ajub and rang up him. And through the phone of accused, he talked with his wife, Nandia Mi, and at that time, his wife Nandia told that Ajub had prepared dinner for them and they will have their dinner in his house. And after time, the accused again called him in his phone, to which he got annoyed and asked the accused as to why he is ringing him time and again, to which the accused told that his wife is with him and he can't talk with her. And when he denied to talk with his wife, the accused questioned him as to at what time he is expected to return home, to which he told the accused that he will come home next morning. The informant further mentioned in his report that on 26/12/2017 at about 7 a.m., when he, along with his wife, with his friend, Dinesh came to his rented house
found his entrance door was little bit open, and when entered inside, found his wife and daughter were lying dead, and his son Surat Minj was crying by sitting near his mother. Thereafter, he called all the neighbors to his house and suspected that someone committed murder of his wife and daughter and attempted to commit murder of his minor son Surat Minj. By lodging this report, he requested IAC to take appropriate action against the culprit.
So what are the evidence? Circumstantial evidence?
Circumstantial evidence, my lord, here only comes out that neighbor, Ajub, in whose house the party was there, and he was just adjacent to the deceased house. And his statement is absolutely silent about whether he has committed the present appellant has committed.
Come to paragraph number 7.
Yes.
Internal page 12, drawing page 31.
Admittedly, there is no eyewitness to the alleged incident. As for the prosecution allegation, on the eve of Christmas night, when all were busy in observing the festival in the house of Ajub Lugun, PW8, in the meantime, the accused, by taking advantage of absence of the informant in his house, approached the deceased Minj for sexual favor, and as she did not agree for the same, he throttled her neck, causing her instantaneous death. And by that time, when her daughter woke up and stated to disclose the matter before others, the accused also killed her by throttling her neck with an intention to wipe out the evidence for all times to come. And thereafter, when the informant, 3-year-old son, Surat Minj, cried, the accused also assaulted him, causing injury on his person, and fled away from the spot. And on its next morning, when the informant and his friend Dinesh returned from the duty, found his wife and daughter were lying dead, and his minor son, Surat Minj, was crying by sitting near his mother. So, in order to fasten the criminal liability against the accused,
come to paragraph 8.
Yes, ma'am.
Page number 36, internal page 15.
The prosecution has mainly relied on the following circumstances. The first circumstance is that on the night of occurrence, Christmas festival was being celebrated in the house of PW8 and PW12, which was attended by the accused and other informant's wife and children. The second circumstance is that in the occurrence evening, on the relevant evening, in the absence of the informant in his house, the accused talked with him through his phone and asked the accused to talk with his wife, Nandya Minj, and the informant also talked with her. And after some time, again, the accused talked with the informant in order to know about his movement. The third circumstance is that the accused, after killing the wife and daughter of the informant, confessed his guilt because his close friends PW8, PW19.
So external confession is there?
Yes, ma'am.
So PW8 and PW19.
Yes, ma'am.
Yes.
With whom he had been to attend the Christmas party in the house of PW8 and PW12, and in presence of PW27 at PS. And the fourth circumstance is the cell details report exhibit 24 showing the conversation between the accused and the informant on the relevant evening 5:31 p.m. in the house of PW8. Undoubtedly, in this case, there is no direct evidence of the crime. The prosecution case thinks on the circumstantial evidence. It is an accepted proposition of law that even in case where no direct evidence is available.
So how do you get over, let us say, these two evidence that you have extrajudicial confession before PW8 and PW19, and both are your close friend, and PW8 has stated that this is Salil, yes. 9:30, Salil called me to bring liquor. I gave liquor bottle to the accused who consumed along with so and so. Again, they went to the program on the next year.
But said PW8 in his deposition.
The accused was already there asking about the incident. He confessed to have killed the wife and daughter of the informant under the influence of liquor, and in the pretext of drinking water, he had been to the house of the informant and asked for water. And when the wife of the informant protested, the accused attempted to rape for and so evidence is on and
Para 4 of the petition. Para 4 of the petition.
That's an easy. 19 became hostile actually.
19 has stated that in the police station it was done. So even if that is excluded, but still then PW 8 evidence.
The chief, what he has stated here, that is the only anxiety I have. But he has no direct knowledge. What he has gathered.
Direct knowledge is on coaching more direct knowledge.
And that too he stated here. He consists of killing the wife because
witness to the extrajudicial confession.
Yes, ma'am.
And that extrajudicial confession is there in paragraph number 4.
Yes, ma'am.
What's the right
7 years, 4 months. December 2017.
Double model.
12.
Summer vacation for the next.
Item 12.
Yes.
Item 12, my lord, there is an IA for condemnation of delay of 62 days.
Speak a little louder.
My lord, in this, there is an IA for condemnation of delay of 62 days.
Aguru delay condon heini.
Notice that to the informant.
Notified in short price. The postcard.
Where is the document that notice has been served? Kimti intimation file is. The document beyond one of the offense under which he has been found guilty requires the notice to be served. So that is why the order was passed. And if you have served the notice, in spite of that, he is not coming. That should be on record. Learning Council for the state has produced. Okay, Nadi City. She is subject and found for them because. It was you. It was you. Huh? The Learning Council for the state has produced the written instruction received from IAC Dharmasala Police Station dated 16/9/2024 regarding service of notice on the informant. The same is taken on record, non-appears for the informant. IN number 1634 of 2024. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 34 days in filing the criminal appeal. Since the appellant has been sentenced to life imprisonment, considering the grounds taken in the interim application, we are inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned, IA is disposed of, part admit, call for the trial court record. The Learning Council for the appellant shall serve the deposition copies of the witnesses to the Learning Council for the state at a summer vacation for consideration of the interim application for bail and stabilization of time. Yes.
Item 13.
No, please, Your Lordship.
It's already admitted and it's for the PLR. That is already in the record.
Control.
Lower court record that has been called for.
It's all right. So
Lordship. The rest for the application for bail.
yes.
For the appellant convicted under section 302, but there is no eyewitnesses, only one eyewitness which has been
PW1 is the eyewitness.
PW1 is the eyewitness was not supported.
No, one is the brother.
The informant
Eyewitness
has the
ଅଛନ୍ତି କି ନାଇଁ କୁହାଯିବ eyewitness eyewitness ଅଛନ୍ତି ତ
Lordship.
PW1 is the eyewitness whether he supported the prosecution case or declared hostile.
Hostile member.
And I thought PW1 hostile in
The petition of PW1 is the brother member, not the eyewitnesses.
Who is eyewitness?
It's Sudarshan Naik.
PW?
PW1 is the eyewitness.
PW1 ର ନାଁ ହଉଛି
Vincent
Naik. So he is the eyewitness, huh?
Yes.
He saw assaulting.
Can I place paragraph 3 of the?
ପଢନ୍ତୁ.
Yes.
I'll start with the paragraph 2, that is the motive behind the murder.
Okay, read it out.
PW1. Incident took place on 11/1/2022 at about 11:30 a.m. On that day, my deceased brother had gone to the tubewell to take bath and accused Biju Naik, along with two others, namely Badal Naik, Sikun Bisul, had sat near this tubewell and were gossiping with each other with illusion. My brother protested their presence nearby tubewell as the daughter and the daughter-in-law of the village were coming to take water from the tubewell. So there was an altercation between my deceased brother and the accused brother and his friends Badal and Sipun. I interpret to stop the altercation between them. Thereafter, the accused and his friends Badal and Sipun went to their house and I and my brother came to our house. Paragraph 3. On the same day at about 7 p.m. to 7:30 p.m. at evening hour, my deceased brother and my uncle had gone to the shop situated at the end of the village, and while they were returning, accused Biju and his friends, namely Badal and Sipun, the father of the accused, namely Jharu Naik, his elder brother Gopi Naik, brother-in-law Biranji Naik, and a younger father Dada Dasso Naik, who were concealed themselves in a thatched house, came out and assaulted him by means of Gujari, Tangia, Thenga, and brother was shouting loudly. I had gone to attend the nature of court, and hearing the shout of my brother, I came to the spot and found that the accused, along with above named accused persons, together assaulting my brother. Out of fear, my uncle had left the spot. Seeing me, the accused, along with the other named accused person, fled away from the spot, and I found my brother was lying with profuse bleeding, injuries on his person, and intestinal stomach.
ये डॉक्टर की PW12
PW12.
PW12.
PW6 here.
PW?
6.
6 की हाँ
PW6 is the PM doctor.
हाँ the PM doctor बताओ 12 कौन
12 was examined the accused.
नहीं
Kindly, he has stated the injuries in paragraph 2 to 5. May I read the details of injuries?
anything you have brought out from the in the cross examination of PW1 because the evidence is very clear that who were the accused persons and how they assaulted by these weapons and also the doctor's evidence. So anything is there in the cross examination to disbelieve this witness or to create a doubt on his version.
All the complaint said that all the many persons are attacked, but finally it was decided that the arrow was by the weapons of the arrow, but that has not been reflected in the FR as well as the statement.
There are multiple attacks by different weapons. So kindly see paragraph PW3 for a moment. He also said that he has witnessed the
PW3.
PW3.
What type of weapon you accused was holding? Na semti kichi nahi.
No. No, that has not been specified.
Bishop, he was holding an arrow was recovered under section 27. The accused present appeal.
This petitioner.
Yes. PW7 is the witness to this section 27.
No, 27 शिव तो leading to discovery ଦେଇଥିବ କାରଣ ଆପଣଙ୍କର PW1 ପରା ପଢିଲେ PW1 ର evidence ଅଛି accused persons were having
Bhujali,
Tangi and Thenga.
That has not been.
ଆର କଥା ତ କାହା ହାତରେ ଥିଲା ବୋଲି କେହି କହୁନାହାନ୍ତି.
No.
Who has given blow and in which weapon?
Since there are multiple accused persons.
ସେମିତି କିଛି evidence ଆଣି ନାହାନ୍ତି.
You are in custody since? How many years you are in custody?
Incident is of 2022.
Yes, 3 years. 2020.
During trial? You are on bail?
No.
Bail?
No.
Oh. So, what about the other co-accused persons?
They have been
acquitted.
They have been.
They have been acquitted. But come to the judgment, I find that only one accused is there.
They've been discharged. Subsequently, file another petition. They have been trial. Trial has not been finished.
And he is alone.
He lost.
Not, madam.
Yes, sir.
ये जो judgment देखुछन तो?
Yes, sir.
Judgment रे accused जणे अछि ए बिजू नायक.
Yes, sir.
तो चार्ज शीट हेइतला
3 जन.
देखी चार्ज शीट देखी फाइनल फॉर्म से कौन पे दिया है इनको फाइनल फॉर्म लोग है इनको हां नंबर ऑफ पर्संस 4 जन को लोक ना रे चार्ज शीट हेइतला तो आरो 3 जन कौन हैला have you received any have you got any instruction?
I'll take instruction.
चार्ज शीट क्लियरली देखुची 4 जन को ना रे चार्ज शीट हेची ना डिस्चार्ज हेची एक होची फाइनल फॉर्म रे एक नंबर टा होची बिजू नायक माने पिटिशनर तो 2 टा होची गोपी नायक रे स्टेटस लिखुची डिस्चार्ज 3 रे हला बिरंची नायक स्टेटस वाला डिस्चार्ज 4 इला दासो नायक स्टेटस वाला डिस्चार्ज. So that means charge sheet has filed against only one person. That is how said Lekhaichi sir. Sir Lekhaichi final form re. The investigation of the case is completed as there is prima facie evidence under section so and so against accused Biju Naik. Charge sheet is submitted. So what about those who are discharged? Anything was done against them by either by the state or by the
by the state. The petition filed, their trial has not been concluded. They are summoned. At the time of trial, they have been released on bail and
The order should be an additional section to that page 10 of the examination that showed 1319 petition was filed. And and they have been summoned.
Yes. Get that instruction, Allah. Look on the I number so and so. This is an application for bail. The Land and Council for the state has placed the evidence of PW1 Bhimsen Naik, who is an eyewitness to the occurrence. And as per the person of the said eyewitness, apart from the petitioner, some other persons armed with different weapons assaulted the deceased, as a result of which the deceased died. Deceased, who is the brother of PW1. However, on perusal of the final form, it appears that only the petitioner has been charge sheeted, whereas the other co-accused persons against whom the FIR was lodged, they have been discharged. When we made a query to the Land and Council for the petitioner, so also the state about the status of those four persons, those persons who are accused persons who are discharged. It is stated that application was filed by the state. They have been arraigned accused at a subsequent stage, and they are yet to face the trial. However, some more time be granted to obtain concrete information in that respect. Put up this matter after summer vacation. In the meantime, the Land Council for the state shall also collect the criminal antecedent, if any, against the petitioner. Yes.
Item number 14.
May I please, my lord? I am on VC, my lord.
Yes.
My lord, this is an application for bail arising out of the criminal appeal, which was admitted by the.
Permitted, my lord. I mean, pardon, so, my lord. In this case, I am for the informant, my lord. I have some small period, my lord, that I am not gone through the brief, my lord. A short adjournment so that I will, any thought, I am not today, my lord.
This is for the bail, your lordship. For the first time it has come, and TCR is very much there on record, your lordship.
You have received the deposition copy, Land Council for the state.
Paperwork is this.
Paperwork ही रहे. Paperwork था. अपन पाइचन paperwork.
आजा. Paperwork.
अपन informant मैं केबल to appear कर.
वो just appear कर चुके लड़.
The very day when the case was got admitted, your lordship, that is
18/11/24.
अपन ना तो ची. 29/11/2024 रे भी अपन ना थिला. प्रिपेयर कौन पे हेले नी?
काली माला डेट में तो वो प्रॉब्लम रहला.
आगुर प्रिपेयर कौन पे हेले नी? ब्रीफ टा एक्सेप्ट करथिले जा देई थी वो ताकू भी एक्सेप्ट करथिवे. प्रिपरेशन कहीं हेला नी.
Custody period of custody.
Period of custody. He while during the course of trial, he was there for 2 years and 9 months and got released by the honorable court. And after the judgment, that is on 13/9/24, he is inside the custody for 7 months, 11 days as of today, totaling to 3 years, 5 months, and 11 days, your lordship.
This is Bhaskar Vishwar.
That's right.
Bhaskar Vishwar is 1018 days lekha hai chithi.
Yes.
So, Land Council for the you have received the copy of the paper book, Land Council.
My lord, I have not received the paper book. I have, but I have
that has already been prepared. So you can receive the same. So we are fixing it another date, and we are also providing the copies of the paper book to the Land and Council for the informer. Madam, you have received the copy of it? Yes. So what is your good name, Land Council?
Pankar Panigrai, ma'am. Pankar Panigrai.
Dipankar Panigrai. You are appearing from which?
Jaipur, my lord.
Jaipur. Mr. Dipankar Panigrai, Land and Council appearing through virtual High Court on Jaipur, submits that he may be supplied with a copy of the paper book. Let the registry supply him the copy of the paper book, and Land Council for the informant, Mr. Das has also made similar prayer. Let the registry supply the copy of the paper book. The IA numbers one is an application for bail. The Land and Council for the state shall obtain instruction about the criminal antecedent, if any, against the petitioner. Put of this matter on the chances later. Yes. Next.
Item number 15.
Your Lordship, and for the accused petitioner, and paying for COVID fine.
Land Council for the appellant 6 for an amendment for 2 weeks. Put of this matter after summer vacation. Yes.
Item number 16.
On behalf of you have got power in this case. What is your name?
S.K.Sahoo.
S.K.Sahoo. Give the full name. Yeah.
Item 16.
Letter from Senior Superintendent so and so. Death of the appellant. Letter of the so and so passed away. Or like the letter. The Senior Superintendent Circle Koraput WS. So also the letter of the Additional Session Judge Special Judge, which indicates that the appellant is dead. Ibnullah. 2025. According to the jail criminal appeal awaits and disposal. Yes.
Item 17.
The provision of court for no application has been filed by the legal representative to continue the appeal.
390.
And before provide the period also 1 month for the 30 days. 394. Against a conviction from only efforts continue period for them. Applicant sentence of and rise in financial near relatives like that. The no near relatives such preferred any file an application for continuance of the appeal. Therefore, the appeal efforts. They use 394 corresponding provision BNSS corresponding provision that yes.
You are the petitioner along with 8 others.
Now I have received the evidence copy.
Evidence copy.
Right. In fact, there is no evidence at all. Only on the basis of
କିଛି ନାହିଁ ଖାଲି ଶୂନ୍ୟ ଦେଖନ୍ତୁ ଦେଖିଲେ ସିନା କହିବେ ସେ ଜାଣିବେ. Mr. Dhawal and Council has supplied the deposition copies of the witnesses to the Land Council for the state in court today. Will take some time to go through the same. This matter will be commencing from 5th May 2025. Yes.
Item 18.
Yes, Mr. Sarangi. I am concerned only 120B because I was in jail custody at the time of incident.
Received
I
the
was on
deposition
bail.
copies.
That was since long. Since long it was given. In my case, I given that.
On a criminal appeal.
conviction is.
Single death or multiple? Single. Eyewitnesses ଅଛନ୍ତି?
Injured eyewitness.
Just.
The criminal antecedent of the accused.
Yeah. This is now Santi Prashad.
Mishra.
So,
Eyewitness, how many?
PW1 and PW9.
1 and 9.
PW1 and PW9. Eyewitnesses.
Doctor?
PM.
PW18 doctor.
18.
PW18 doctor.
18
Nice.
PW18 PM doctor. ଏଟା ସମସ୍ତଙ୍କ ନାଁରେ ଇଏ ଅଛି
Criminal antecedent.
ଫାଇଲ କରିଛନ୍ତି କମ୍ପ୍ରିହେନ୍ସିଭ ଆଫିଡେଭିଟ୍ ଫାଇଲ କରନ୍ତୁ ଏଗୁଡା ସବୁ
Just ଦେବାଶିଷ ସେଟା କହୁଥିଲି.
ହଁ ଦେଇଦିଅନ୍ତୁ କପି ଦେଇଦିଅନ୍ତୁ the learning
One thing you'll also consider. So far I am concerned, I am on bail since 2014.
ଏଗୁଡା ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କ ନାଁରେ ନାହିଁ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ
ସମସ୍ତେ
14 ରୁ 25 ଭିତରେ ନଥିବ ଏ 11 ବର୍ଷରେ ନାହିଁ ତ ସେ ଟାଇମରେ ଯଦି କଣ
ଏଗୁଡା ଦେଖି ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ ତାର
11 ବର୍ଷରେ କଣ ଆମର କାର୍ଟେଡ୍ ଥିଲେ?
No.
ନାଇଁ
That's what I'm saying.
ଥିଲେ.
The learning
So that's what I'm saying. Past.
The learning council for the state has produced the written instruction received from IIC Gosani, Nuaga police station, from which it appears that there are criminal antecedents against the appellants. The same is taken on record. Copy of the letter has been handed over to the learning council for the appellants in court today to seek some time to obtain instruction about the status of those cases and file a comprehensive affidavit to that effect. এটা ফাইল করি পারিবে ছুটি ভিতরে না ছুটি পরে
नहीं छुट्टी आगु था
अच्छा हो 12 तारीख रखते this matter will commence from 12th May 2025. Yeah.
एड़ा तो 9-10 this case
ସବୁ ଆପଣଙ୍କ ନାଁର ଅଛି ସେ
ନା ଆଜ୍ଞା ମତେ ଗୋଟେ କପି
କହିଲି ପରା ଦେବା ପାଇଁ ସେ ଦେଇଦେବେ ଜେରକ୍ସ କରି ସମସ୍ତଙ୍କୁ ଦେଇଦେବେ
My lord, who is commencing, my lord? It is very difficult to comment, my lord. Specific date ଆସିଗଲେ ଟିକେ
ସେ ପଟେ ଅଛି
12ଟା ଗୋଟେ ସ୍ପେସିଫିକ
12 ନା ସେ who is commencing word ଆସିଗଲେ ସେ
ଆଚ୍ଛା ଆଚ୍ଛା 13 5/2025 ଏଇ ଗୋଟିଏ order
In my case, 2 cases I filed appeal.
ଦେଇକିନି with ପଳେଇ ଆସିବ ହେଲା ସବୁ ଗୁଡାକ କରିବାକୁ ଦରକାର
There I've got one in one case, Ganesh Pandey, I've got one accident which arose out of the same case under section 195A. There he has been acquitted.
ଗୋଟେ affidavit ସେଇଆ ତ ମୁଁ କହୁଛି ତା ଭିତରୁ ହୁଏତ ବହୁତ କେସରେ ଆପଣ acquittal ହେଇଥିବେ କଣ ହେଇଛି ତା ଯୋଉ just ଗୋଟେ
affidavit
yes next item 19
Item 19.
Convicted under 302, my lord. There is a witness only circumstantial evidence, my lord. Last week, finally see judgment page of
ଏଟାର deposition copy ପାଇଛନ୍ତି
Yes, sir. And kindly see running page of 40.
ଆଗେ ପାରା 2 କୁ ଆସନ୍ତୁ prosecution case ଟା ପଢନ୍ତୁ ଆମେ ଜାଣୁ ଆଗେ ହଁ Para 2 of the judgment.
Mine.
Yes.
The case prosecution is that on discovery of the unknown dead body at the Tendwala Bridge, Ratana School lodged a written report before the IAC Disciplinary who registered the report and took up investigation. During investigation, he examined the informant, issued a command certificate to Constable P.N. Puhar to guard the dead body at the spot and send the requisition to scientific team. Around the 10:30 a.m., scientific team as well as the executive magistrate, Srimati Susmita Murmu, additional Thursday from executive magistrate arrived at the spot. The IO visited the spot and had an inquest on the dead body. He dispatched the dead body for postmortem to PRMMCH Valpada along with the dead body challan and collect sample of the blood of
କୋଉଠି ଅଛି direct evidence ନାହିଁ circumstantial evidence ଅଛି ବୋଲି କୋଉଠି ଲେଖା ହେଇଛି କୋଉ paragraph ରେ
paramilers
अब ଆପଣ ଆଚ୍ଛା ଏଠିକି ପଳେଇ ଆସନ୍ତୁ circumstance ଗୁଡା discussed ହେଇଛି sum up ହେଇଛି paragraph number 6 ରେ
page 22 ରେ running page judgment ଲେଖା ହେଇଛି whatever evidence available in the record set of certificates evidence. This is the para 22 ରେ ଲେଖିଛନ୍ତି and the last para 30 ରେ last century
ମାନେ ଗୋଟେ ଏତେ circumstance ସବୁ ଲେଖା ହେଇଛି paragraph number 6 କୁ ପଳେଇ ଆସନ୍ତୁ
paragraph 6
अच्छा evidence गुड़ा किटी analyze है okay okay then आसन evidence पढ़े आसन circumstance को पढ़े आसन पूर्ण लगता है वो paragraph
para 7 year
para page number क्या देखो
page 35 internal page 22
अच्छा analysis of the evidence there is no direct evidence. So whatever evidence available in the record is the shape of the circumstantial evidence. कौन circumstance असला अपनो नारे?
माला कहने से para 30 ना page 30 ना para 18 page 30 running page 43 judgment page 30 running page 43
नहीं death of the deceased data लिखा ला I hold that the death of the deceased was homicidal by compression of neck. That is 9 paragraph of conclusion. तापरे असला ये कला नेक को compression to that effect अच्छा ये police custody statement है record वाला
police custody statement those are present they are hostile PW 16 and 17
चले रहिला कौन आओ
PW 13 only last thing theory PW 13
13
mind and 18 mention malor the evidence of prosecution show that para malor 18 judgment para
18 page के देखो page के
30 judgment 30 running page 42
हाँ
this is what the last thing which the accused on 4/6/2021 around 4 p.m. Dead body found minor next day 6 p.m.
पूछेंगे केवल लास्ट सीन अच्छी आओगी
The lordship, no, lordship, I'm coming back. Lordship, may kindly have a glance at PW 10 year lordship. Is the deceased? The whole story is that this accused person had married the deceased lady, but subsequently they did not had any child. Subsequently, he attempted to marry a second time without disclosing it to first wife. He was almost on the verge of getting married. This information was provided to the wife, the deceased, to a friend. The wife arrived at the spot. She started she started a scene at that. And subsequently, there was a scuffle between the husband and Lordship. May kindly have a glance at PW10.
Thereafter, what happened?
Thereafter, the wife took her husband to the nearest police station.
PW30.
1 minute. He's
Lordship, I've been permitted to place.
And you tell whatever.
See, police station jaisala pare so tanko bhitere so mimamsa hela mimamsa hisala pare see
no police called the accused to the police station, not that he took the accused to the police station.
Yes, Lordship.
So he complained before the And police called the appellant to the police station.
Yes, Your Lordship.
Yes.
PW17 is also the diary charge officer.
All right, there was, he undertook that not to subject the deceased to harassment.
Yes.
Right, and second marriage was cancelled.
Yes.
So that is one aspect. So, all right, this thing has happened, but what about the occurrence date? Occurrence date the no, PW13 कहुची
Yes, sir.
जे ये दी जन initially the accused.
Schedule 13 in cross examination, the accused Chumki police station about 1 to 10:30 am. On that day, the working they also left the Sunguria about 4 p.m. by walking.
Dead body could मिला.
Under the culvert. The post
And he has stated in chief examination. After 2 days, I came to know that the dead body of a Chumku was found, and thereafter being contacted.
He has seen that both of them are going
in the police station
to the village.
The police station se gale. This is
तापर डेड 2 दिन पर डेड बॉडी
तापर next day 6 p.m. रे dead body पाए. Then lodged the FIR detected police FIR lodged PW1.
No, PW13 evidence which page 2 re.
Aiyah.
That the accused and Chumuki is the deceased, left the house of Ajmutan by telling that they would go to their native village and came towards the road to pick vehicles to go to Baleswar station. That's
very important. That 2 lane. That 2 lane. After 2 days, came to know
dead body ta milila onne gote jagare.
And when he contacted the accused, he told that Chunki had eloped with another boy.
So, see you, तामाने dead body मिलिबार 2 दिन पूर्वरु आपण दी जण को देखा हेतिला कहिले जे हमें नेटिव विलेज को जाऊ ए होची केस.
And the accused subsequently told that Chunki, his wife, has eloped with someone else when he was confronted.
The contact college is
Trying to justify that. This is the only strong piece of evidence according to prosecution. Undergone how
kete varsh bolani
custody my lord 7/1/2020
year
by
during trial you were on
no man
bail.
First.
In total, how much?
Total 7/1/2022.
7/1/22.
7/1/22. Incident केवल.
Incident my lord.
3 वर्ष incident होची.
Not sure at the time of the judgment, it was 2 years and 5 months.
हाँ नहीं 7/1/22 माने 3 वर्ष और 3 मास देची अब incident
Date of incident is 4th or 5th.
हाँ
6/21.
देखा है. Petitioner and counsel for the state and counsel for the petitioner submits that the petitioner is in judicial custody since 7/1/2022. And there is no direct evidence in the case. Case is circumstantial evidence. And the main circumstance is the last scene of the petitioner in the company of the deceased Chumki, which is deposed to by PW13. And he has stated that 2 days prior to the dead body of the deceased was recovered, he had seen the petitioner and the deceased going left Sunagadia at about 4 p.m. by walking. the Land Council submits that in absence of any other evidence, basing on the last seen evidence as adduced by PW 13, it would be difficult to sustain the order of conviction, and therefore the petitioner has good chances of success in the criminal appeal, and balance of convenience is in favor. Therefore, the bail application may be favorably considered. Stop. Land Council for the state, on the other hand, oppose the prayer for bail and argued that the petitioner, after marriage with the deceased and after since they were not having any children, he developed illicit relationship with another lady, which was detected, for which there was quarrel between the petitioner and the deceased, and that is the motive behind the commission of crime. And after the deceased was seen in the company of the petitioner, she was not found alive, and the doctor bracket PW doctor postmortem
PW
22 conducted postmortem examination has opined that the cause of death was due to asphyxia resulting from compression of neck, and therefore he should not be released on bail. Considering the submission made by the Land Council for the respective part, the absence of any direct evidence, nature of circumstantial evidence available on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail with the law.
Item 20.
I'm a page on highway. I filed item number 11/25.
Yes.
Last of the lordship is directed to take instruction with doctor's marriage of the petitioner.
Doctor's marriage.
Yes, my lord.
Dr. Quebec.
April April, my lord. 30/4/25.
Local look na bahar
Local. Local man of Ganjam district.
Ganjam. ବାହାଘର କେବେ ହଉଛି 30/4/25 ଆଜି ହେଲା 24 ତାରିଖ ନା 23 ତାରିଖ ନା 24 କେତେ ଟମାଟୋ 7 ଦିନ ତ ମିନିମମ୍ ଦରକାର ସପ୍ତମ ସରିଲା Look, the IA number 1150 of 2025 is an application for interim bail on the ground of marriage of the daughter of the petitioner, which is going to be solemnized on 30/4/2025. As per order dated 22/4/2025, the Land Council for the state has received instruction from the IIC Tarasingi Police Station, Ganjam, which indicates that the marriage of the daughter of the petitioner is going to be solemnized on 30/4/2015 at his residence. The written instruction is taken on record. Considering the submission made by the Land Council for the respective parties, the government's taken in the interim application, the written instruction received by the Land Council for the petitioner, we are inclined to release the petitioner on bail for 2 weeks for the hours from the date of release.
3 weeks.
Oh, 3 weeks for period of 3 weeks from the date of release. Matter to be placed after summer vacation, he is to file the surrender certificate. এটা কোন admission in time, এটা admit করে দিন। Mr. Jafrullah is there? আচ্ছা, ঠিক আছে। এটা admit করে দিন।
Not admit.
We have admitted it?
Yes, ma'am.
The 302 case, no?
Yes, ma'am.
Judgment of 302 live imprisonment is. Sure.